Present item number 1.
Yes. Let's see the order dated 21/5/2024. And the director of the government.
You are seeking review at 18/3/2024.
Yes, order dated 18/3/2024.
What is wrong in it?
That the petitioner has tried to work out the government decision by the annexure to page 14.
Two,
To work out the government decision because the Tahsildar has debated the decision of the government.
so that can be taken care of by the concerned official.
The officer has not taken consider whether the Tahsildar debating the government decision has prepared to construct the office at another place. Therefore, the petitioner prayed for a direction to direct the Tahsildar. He will work out the government decision without debating the direction of the government. That is annexed to page 14.
We are going to impose exemplary cost in this case. You can challenge this order. Petitioner had filed a writ petition in the nature of public interest litigation, questioning the petitioner in the present writ application. Present application is seeking review of an order dated 18/3/2024, passed in WPC number 18609 of 2023, which reads as under. Stop. Learned counsel appearing on behalf of the petitioner has submitted that the petitioner in fact had not questioned the decision of the state government. Rather, he had raised a grievance that the Tahsildar was acting against the decision of the state government, acting in deviation from the decision of the state government. So stop. Stop. The synopsis was filed along with the said writ petition in the public interest litigation. Relevant portion of it reads as under. Stop. In the where is that synopsis? While disposing of the said writ petition in the nature of public interest litigation, we had opined that in a proceeding of judicial review, in exercise of power under Article 226 of the Constitution, the court is not supposed to enter into such disputes which are primarily of executive in nature. So stop. Next. By filing the present review application, in the court's opinion, the petitioner has abused the process of the court, which deserves to be dismissed with a cost which is quantified at 10,000 to be paid by him in the account of for Advocates Welfare Party. Within 3 weeks from today. Function on that. The principal accused already decision bill, but the accused they will behind the bar. Hence, the honorable court we can be directed to take up the matter before honorable justice. This mention you should not make, that this matter should be listed before honorable so and so. You should not mention that in your memo and correct your memo and give it to the deputy registrar. We'll see.
Pardon to mention my
For that within the several memo I have. You give that today, you tell that Chief Justice has said, all right. The principal could always release a case. If somebody could have already given reason. Give your slip there, I'll see your slip.
I beg my lord's pardon, make a mention, my lord. But this is that law student's case, my lord. It is only pursuant to your lordship's intervention. They filed an affidavit allowed to sit for the classes and as well as to sit for the exam. But now, when the classes are over, when the examination is supposed to be
Law or medicine?
now they're asking me that you pay
Medicine or law?
law student. Now they're asking that if you pay that 15,000 which has been imposed as fine, then only will allow you to sit for the exam. And all through your lordship has been trying to impress upon them that to show compassion. But now they're saying that you pay that 15,000 despite the matter being sub judice before this honorable court.
They should pay that amount, 15,000. We shall record in our somewhere that should not be treated as stigma for in the future.
My lord, I bow down, my lord. I'll pay that amount.
Respect the decision of the institution also.
Grateful, my lord. I'll pay that amount. Your lordship may take up this matter sometime, my lord.
We will take up the matter.
Can I give them
Once you pay that amount, you make a mention, we will take up and pass appropriate order.
Grateful, my lord.
But do it fast.
Yes, my lord.
So that
I beg a pardon. Pardon to mention my lord.
The face admission matter, it has not been admitted in 2789 of 2023.
no, wait for some time. Please wait for some time. We have so many matters. Please wait for some time. 2 weeks you can wait. There is already an order against you. So, no hurry.
Pardon to mention my lord, the contempt matter, the pension benefit, my lord. On board your my sir on 4724. Thereafter it is not listed.
47/2004 contempt.
Contempt, my lord.
Contempt.
Yes, my lord.
Pension has not been paid.
Pension has been not paid.
There was direction.
There is my lord.
All right. Give your slip to Mr. Samantra.
May I to mention my
Give this slip to him. Can tell him, Mr. Samantra, please. All such matters, the mention shall be made in your chamber.
Pardon, my lord. This is a fresh admission tender matter, my lord. The petitioner challenged the passing of the entire tender process because by the process, the lower class contractor, that is C class and D class, has been divided to participate in the tender process in the local body government. Therefore, he seeks for
What is wrong in it? It's a policy decision.
my lord, policy decision. Thereby, the petitioners are being divided to participate in the
Right,
tender process.
right. So you are
But
which class?
in the local body government,
You
my
are
lord,
which class?
we are D class.
You are D class. So you have been excluded.
Already, as per the tender condition, we are not able to participate in the local body government.
All right. So if there is a long bridge is to be constructed, can you participate?
No, my lord, they are what they are doing in the small package of work, they are clubbing the small package of work and making it a big package. Thereby, they're dividing the C class and D class.
That they can.
Whereas A class and above higher class contractor, they are participating in the local body government, whereas they have no work to do.
Seriously, we will see. We don't-
my lord's
Fresh admission matter.
We will see. Fresh admission automatically these cases are listed. Fresh admission.
take my lord's permission to make a mention.
Yes.
In fact, one number 39, where I'm supposed to file a reply affidavit, last date your lordship passed that order. I have taken consent from the appellant's counsel, Mr. S.P. Misra and senior counsel. But I am in the process of arranging documents to file affidavit.
Ask someone to be here when the matter is called.
That's
My lord, I am on behalf of the appellant present here.
Please be here when the matter is called. Please let someone be here when the matter is called.
My lord, next. My lord, excuse me. My lord, any day next week, my lord, for item number.
Please, Mr. Counsel, please be here when the matter is called. We will fix a date as per your choice. All right. Our convenience also. Sir. Yes.
Item 22 of the list, my lord. I'm going to respond that. I've also asked for the appellant, my lord. I need a small update.
All right. Be here when the matter is called.
Pardon to mention, manner. Award passed by the PLA of Baleshwar is under challenge. After dismissal of the writ petition, the executing court is proceeding in the matter, and the date was fixed to 13th of August.
What is under challenge?
Award passed by the permanent Lok Adalat Baleshwar.
Is under challenge.
My lord.
Why have you come here?
After that, we have filed a writ petition, which was dismissed by the single judge.
This is appeal, inter-court appeal.
My lord.
It will be listed.
The executing court was date was fixed to the 8th of August.
Not urgent. Not urgent.
Pardon to mention, Your Lordship.
Or no.
Your Lordship, this is a writ appeal filed by the Union of India, Your Lordship, against an order passed by the learned single judge that was passed in my favor, Your Lordship. The direction was to allow me to close my term deposit accounts and withdraw my amount, Your Lordship. This writ appeal has been preferred since 2023 and it has not been admitted as of date, Your Lordship. And for that, my order is not being able to be complied, Your Lordship. I've also filed a contempt, but
You cannot make a mention. You can take consent from if the appellant is ready. A different matter. Let the appellant make a mention. Respondent cannot make a mention for hearing of an appeal.
the order is not being able to comply, Your Lordship.
That you may have different forum.
Oblige, Your Lordship.
Item number 1.
Please, my lords. Please, my lords. I am here.
Yes.
My lords, I have made a compilation of the judge.
For the insurance.
Yes, my lords. Appellant, my lords.
For just a minute. For insurance company, who is here?
We have sent them through mail the copy of the petition along with the request to appear. Nobody
Send it to whom?
sent to the company, insurance company, as well as the S12 counsel who was appearing.
Who was the counsel?
In the writ petition, who was appearing.
Who was the counsel?
Nirmal Kumar Mahanti, someone appearing for in the writ petition.
Yeah. Issue notice. Issue notice. So, respond number.
Why have you filed a dispensing with filing of sorry. Original certificate by way of net loaded, downloaded copy. That's all it.
Why did you not file certified copy?
My lords, it has been, my lords, it has been applied for, but not provided to us as yet.
When did you apply?
My lords, it is there with my, associate.
When did you apply?
We applied through online mode. So the first judgment since was reserved, the first order was we get the first order, but the entire order we could not able to obtain. Therefore, on urgent basis we have filed, and in the meanwhile we have applied the or certified physical copy of the certified copy.
Now, when did you apply for online certified copy of the?
My lord, I'm just checking.
Mallards, I'll find out.
I just want to understand the system.
Yes.
When did you apply online?
Let's for a minute, please.
Mr. Panda, you said something that you got part of the copy. I couldn't understand what you mean by that. That you got part of the copy.
Part of the first that was shown that the order is resolved. That part first order, which is also uploaded in the official website. But the entire judgment we did not receive.
Entire judgment is here. Here, attested, downloaded from the website.
When did you apply for certified copy online?
My lord. Sorry, my lord, I don't have the receipt right now.
All right. Where is your application? We are rejecting your application then.
Because your application, you have said in paragraph 4 that the petitioner has filed a certified copy on dated dash, but same has not been obtained provided to me. What is the meaning of that?
No, Mallards, may kindly be passed over. We have definitely applied for, and I'm trying to find it out. Mallards, it is not
Parashar,
readily available.
your petition is not in order.
No, Mallards, that may be a technical Mallards lapse on our part.
not-
It is there, but we have applied.
See, you are blaming the institution.
Of course not,
That you
Mallards.
applied for the certified copy and you could not get that.
He has not stated.
Mallards, I'm not blaming the institution.
Yes, you are blaming. You have not mentioned the date, and we are concerned about it.
Mallards, may
You
kindly
are
say.
taking steps to ensure that you get the certified copies.
Mallards, may kindly, please bear with me. I'll within a few minutes, I'll be
We'll see
showing
later.
to the Honorable Court that we have actually applied, Mallards. It is not, printout is not there with me, but I'm stating at bar, Mallards, that we have applied, and if I am found to be wrong, then I don't have any right to be before the Honorable Court. So we have, Mallards. So, but we don't have the right now,
Yes.
the printout.
You accept notice on behalf of?
On behalf of the
Three.
respondent number 1.
Yes.
Mr. Suryakant Dwivedi, my instructing lawyer, will.
Yes.
Item number 2.
Mallards, may kindly say,
I'm sorry, my lords, 1 and 2. The 2 is the minor daughter. So 1 and 2 we will be. I'm so sorry.
Item number 2.
May I please?
Mallards, I have made out a prima facie case, Mallards. My appeal would be rendered infructuous. In case I am not protected, because he can produce the successor certificate anytime. And in that event, the entire proceeds would be will be paid to him. So, Mallards,
I'm placing from the first case that WPC number 10185 of 2024.
Mallards, we may kindly be protected, Mallards. I'm sorry for this technical lapse on our part. So,
Yes.
Well, may I draw my lord's notice to page 53, annexure 2 of that read petition.
Which one? WPC?
The first WW 101855 of 2020, the first case. Chittaranjan Ghare.
Yes.
After 2012, the Parent Act rule, the first amendment was made on 31st October 2014. That part, Your Lordship has seen that rule, Your Lordship has seen the two. In Odisha Engineering Service Method of Recruitment and Condition of Service Rule 2012 for Sub-Rule 3 and 4 of Rule 7, the following rules shall be substituted, namely the Commission on receipt of the requisition shall take steps to select the candidate in the manner given below. Selection shall be based on objective type written test and viable. On objective type written test shall be 90%, weightage on viva post shall be 10%. Prior to that, the three methods are there. LRC can find it from Annexure 1. There was a weightage of career evaluation shall be 50%. In original rule, that selection shall be made by career evaluation on the objective test. Thereafter,
No, we are not on the original rule.
I'm coming, Mel. That was amended to that effect. Thereafter, 2020 rule, LRCMC 2021, page 4, which was the subject matter challenge in the previous read petition. LRC can find it page 54.
Yes.
LRCMC, the date is 28th January 2021.
Yes.
For the first time, the system of gate, LRCMC page 55.
Yes.
The commission, after receipt of the shall take steps to select the candidates on the basis of the highest of the valid gate scores of preceding 3 years of the date of advertisement, including the year of advertisement. Here, well, 3 years. LRC mark that 3 years. And in accordance with this rule, the advertisement was made at Annexure 5, page 58. Two dates are crucial dates. First, rule was amended on 28 January 2021. The advertisement was made on 18/3/2023. 18/3/2023. So two dates are crucial, but I'll submit why the two dates are crucial. This rule as well as this advertisement was challenged in WPC number 157 of 2022 and batch of cases. In some cases, that virus was challenged. In some cases, virus as well as the advertisement was challenged. Because the batch of, and all the matters were taken up together. What are the ground before the announcing in earlier read? What are the ground for challenging the virus? Basically, 4 grounds are there before my lords. While amending the OS rules 2012, the provision of Article 322 of the Constitution of India and the rules of business have been given a go by. Second, the opinion of OPSC has not been placed correctly before the cabinet, and a wrong statement has been made before it that the OPSC has given its concurrence to the proposed amendment. Third, enough time opportunity to appear in the gate examination thrice before the publication of the advertisement on 18/3/2003 have not been provided to the candidates. Fourth, amendment has been adopted in an arbitrary manner, and by such amendment, the function of the Public Service Commission has been reduced to that of a ministerial job,
meaning thereby the said amendment has been excluded function of the Public Service Commission as enshrined in Article 320 of the Constitution of India. These four grounds are there. Fifth ground that by adopting the GATE score, they cannot eliminate the candidates and they cannot substitute the written test. These five grounds are there. Your Lordship can find it from paragraph 19 and 20 of the judgment, Your Lordship, at page 67, the judgment. It starts from page 101. ma'am.
Yeah.
May I read my para 9? Why I am submitting some letter? Why I am submitting? Because only on these grounds, the virus of that 2021 rule was challenged. This was the submission. Mr. A. Mahathir, Senior Counsel, assisted by Mr. S. General Counsel for the petition, has submitted that the petitioners who are the aspirants for the post of Assistant Executive Engineers under the state government confined their challenge to Rule 4 of the Impunity Amendment Rules 2021, which amends Rule 7.3 and Rule 7.4 of the OS Rules 2012. On coming to learn about this amendment, they, along with other aggrieved aspirants, the Principal Secretary of Water Resource Department by filing a representation dated 23/5/2022. But when this was not considered, they filed the writ petition. Notice had been issued to the opposite party, and they have filed counter affidavit, and reasoned affidavit has been filed by the petitioner in reply to the counter affidavit of opposite party number 1 and 2. But before the matter could be finally adjudicated, the Odisha Public Service Commission, Cuttack in cert, has published the advertisement number 20 of 2022-23 for recruitment to the post of Assistant Executive Engineer Civil and Assistant Executive Engineer Mechanical in Group A of the Odisha Engineering Service under the Water Resource Department on 18/3/2023, prescribing the GATE scores to be the basis of selection, and 24/2023 has been indicated to be the last date of application. Challenging the substitution of the method of selection through GATE scores, Mr. Mahathir and Counsel has submitted that syllabus of GATE is designed for higher study and entry into higher education institution and has nothing to do with the selection of engineers for services. Candidates who have never applied for GATE will be deprived of applying to the post as generally as after completion of the engineering courses. The candidates have prepared for appointment state government, or most of them do not prepare for appear in the GATE examinations. Fresh engineering graduates opt for appearing in the GATE examination for the purpose of higher education and for joining the public sector undertakings, while many engineering graduates join private companies and prepare for government service by appearing in the examination held by the OPSC. GATE is an examination for admission into the master program and doctorate program and recruitment of some public sector undertakings, and it is not required for engineers who will serve the state government. The amendment has completed.
Should be completely, it is complete.
Sorry, madam. The amendment has completely changed the examination selection method, depriving the aspiring engineers who have not appeared in the GATE examination from applying for the post under Odisha government, which is violative of Article 14 and 21 of the Constitution of India and therefore liable to be set aside. He has also further submitted that Article 323 of the Constitution of India specifically provides that at the time of recruitment to the civil post, the state shall consult the Public Service Commission, but the input notification amending the rule has been made without considering the opinion of OPSC. As the OPSC has specifically questioned the substitution of the method of written test and viable by GATE score. This is apparent from the statement made by the opposite party number 1 and 2 in paragraph 4 of their counter affidavit. By letter dated 4/3/2016, the suggestion had been given by the OPSC to make amendment as per suggestion number 2, so as to get better candidates to the post. But at complete disregard to the said suggestion, Rule 7 has been amending to confining it to GATE score, which appears to be arbitrary and irrational. He has submitted that no doubt the opposite parties have the power to prescribe the qualification of the candidates for appointment, but prescribing GATE score has the only basis for recruitment by passing the written test and viable test and thereby depriving the more meritorious candidates who have never appeared in GATE is arbitrary discriminatory. GATE scores have not been made the sole basis of recruitment by the PSU. Like companies Bell and Hall are still recruiting engineers on the basis of computer examination and interview to half duration consisting of MCQ on general awareness and 100% MCQ on the concerned discipline. Then para 20, the submission of Mr. B. Rautra, Learned Council, same time. But Your Lordship decided the matter in para 26.
Now, Mr. Kutia, you should keep in mind one thing. If you argue res judicata, that will not apply.
No, my lord, I will, so, yes, I will not argue. No, I will not argue on that.
Principles of constructive res judicata, those principles.
No, what? No, what? No, I am not. What I am saying, I will not answer on those points because they have argued on that. These have been discussed in earlier paragraphs.
No.
So I want to brought my lord's notice only to para 20, under what circumstances this rule was declared, 2021 rule was declared.
See, if you make a rule or any enactment that is challenged on several grounds, the court may strike that down on one of the grounds.
Yes, ma'am.
It does not mean that all other grounds were turned down.
No, that I don't.
This is one aspect.
Well,
and the other aspect is that this is a fresh challenge
well,
to fresh set of rules,
well,
statutory rules.
Well, I only try to bring my lord's notice to para 26.
We'll go to that. We have heard it yesterday. We'll put in mind that you've changed the rules. As you've changed the rules, had the same rules been subsisting also, that is a little slightly different. You have amended the rules.
Yes, that for that reason they have challenged the virus. Where that route, Your Lordship, the conclusion part, my Your Lordship,
Which page?
Page 157. In view of the fact that advice opinion of the OPSC has not been placed correctly before and a wrong statement has been made before it that the OPSC has given its concurrence to the proposed amendment. Rule 4 of the amendment rule, which amends Rule 3 and 4 of the Odisha Engineering Service Rule 2012, is liable to be struck down. Consequently, the impugn advertisement having prescribed the highest valid gate score of the preceding 3 years of the basis selection is liable to be quashed. An additional ground for quashing the impugn advertisement is that candidates have not been provided enough time opportunity to appear in the GATE examination thrice before the publication of the advertisement dated 18/3/2023. The highest valid GATE score for the preceding 3 years from the date of advertisement has been provided in the method of selection in the advertisement, thereby depriving candidates who are not appeared the GATE examination in the year 2021. The process for which admittal began in 2020 before the publication of the amendment rules, which were published on 28/1/2021, while the advertisement has been published on 18/3/2023 of a level playing field, placing them at a disadvantaged position as compared to candidates who are able to appear in the GATE thrice before the publication, thereby discriminating against them. On 2 grounds, Your Lordship has quashed it. Government think not to challenge before this order, not to challenge this honorable apex court. So, because that is last sentence of this judgment, para 46, page 169.
So the view which was taken, according to you, is correct because the government decided not to challenge.
Yes, my lord. Government decided not to challenge, and government has not challenged. No, sorry. Government has not challenged.
I was saying something else. So according to you, the view which division bench had taken is correct because the government had not
Yes, my lord.
decided
Why,
to challenge.
yes, my lord. Why that is correct? That in fact, what has been recorded in that what has been recorded in that judgment, my lord,
All right.
the OPSC opinion has not been correctly placed.
All right,
That is
that
the
was-
admitted fact. There is no dispute about
Yes,
that.
yes.
And it is also admitted fact, chances are not before that admittable that so I was pointing out two dates that are the crucial dates.
We have understood your
Well,
submission, Mr.
So government decided not to challenge the same. Let me see the last line of that judgment.
Yes.
Para 46 at 169.
Yes.
The state may frame the rules observing the procedure as prescribed by the law, not defense thereof. So then I'll bring to my lord's notice my counter. I filed it on 25/6/2024. Why I have submitted, the government has decided not to challenge. That has been reflected in my counter at page 21.
No, we have that.
Counter affidavit in the present writ petition.
Yes, in the present,
Oh,
you'll
yes,
also see
name.
my counter affidavit,
Page.
page 20 of my counter affidavit, my lord.
256 or what?
Manjulata Swain,
Yes, my lord.
page.
There is no
Internal-
page 21 in the counter. Yeah.
In LOC is looking at the counter on
Counter.
25/6/2024.
Just a minute. Manjulata Swai or something else?
Manjulata saying LOC,
Internal page,
my internal page 21. Up,
21 minutes of the.
Yes, ma'am.
Oh, the annexure. All right.
61.
sorry, my
Got
lord.
it. The annexure. All right.
LOC may said page 22.
Annexure B/1.
LOC got it.
Yes.
After thread but discussion and deliberation, the following decisions were taken. SLP may not be filed against the order that 1/5/2023 of the High Court of Orissa passed in WPC number so and so to avoid further loss of time.
Oh, what kind of decision is this? That the order may be illegal, but we will not challenge because
No, Court has, I have read that last part of the phrase proposal be sent to the OPSC for seeking their concurrence on amendment of the cadre rule, that is the Odisha Engineering Service Method of Recruitment and Service Rule 2012 for recruitment of assistant engineers by adopting valid grade score for preceding 2 years instead of 3 years proposed in lieu of written so as to ensure on transparency in the process of selection, entry of talented engineers to the Odisha engineering cadre from a wider pool and resources and timely completion of the recruitment process. To cure the defects as per the observation of the Honorable High Court of Odisha, the draft engineering service amendments will be placed before the cabinet afresh for approval.
So this, the state has taken all the actions in conformity with the provisions contained in Article 323
Yes,
of the Constitution and deviated from the advice of the OPSC in consultation with GA Department, Law Department after obtaining approval of the Honorable Chief Minister, Head of the Cabinet, giving adequate justification. That means, so the Cabinet need not be aware of what has happened as long as the Head of the Cabinet is aware.
Lordship is then annexure C/1. Page 24. Before that, I'll bring to my lord's notice page 25.
But if everything was all right, why was fresh proposal necessary to be sent to the OPSC?
Because in that earlier rule, 100% gate score was there. So accordingly, fresh proposal was submitted before the OPSC. OPSC submitted, your lordship may see page 25.
Yes, yes. Page.
Page 25. Annexure D by 1. That this was the opinion of the OPSC. Recommendation of candidates only on the basis of GATE score leaves no scope for the commission to conduct examination for appointment to the engineering service of the state. Therefore, such a provision will be in derogation of the constitutional provision. The commission, after due deliberation and having regard to the provisions of the opinion that there shall be an interview for shortlisted candidates on the basis of GATE score, and the number of such candidates may be up to 2 times admitted vacancy category wise. The merit list the merit list shall be prepared on the basis of aggregate marks equal in GATE score, which shall carry 70% weightage, and in interview, which shall carry 30% weightage. In view of the may consider and incorporate the above provision of the proposed amendment to the Odisha Industry, so and so. Thereafter, the government decided not to 30% because it should be reduced to. This was approved. Page 27. Inviting reference to letter, I am directed to say that the commission have given plea to reconsider their earlier so far as relates to weightage of GATE score and viable test mentioned at para 4 of the letter under reference, which is modified to the extent the proposed weightage of 30% for interview can be modified to 10%, having 90% allocated to GATE score on the recruitment to the post of assistant executive in the civil and mechanical. In view of this, the department may consider and incorporate the above provision in the proposed amendment to the Odisha Engineering Service Method of Recruitment and Condition Rules 2012. So these are the opinion
Where
of.
is that letter dated 27/2023 in response to which OPSC has given this reply?
And Mr. Khutia, these are irrelevant for this court to consider the challenge. The communications between the state government and OPSC can demonstrate that there was a consultation between the government and the OPSC, and that consultation was effective consultation.
Yes.
All right, that's all. Nothing more can be culled out from these documents. What opinion was given by the OPSC? Material. Again, the OPSC was requested. Again, OPSC gave some opinion. Not material. For the purpose of challenge. So it's a different matter that the court can see whether in this case even the OPSC was influenced. OPSC is an independent body. So was the OPSC being influenced by the state to give a particular advice?
Yes.
We will not go into that. Will not be these documents so that there was. Please, Mr. Mark, you can.
So your submission is that OPSC was duly consulted.
Yes.
All right.
And ultimately agreed to your proposal.
Yeah.
Ultimately agreed.
Please come.
But the agreement is not actually material.
No, that I cannot say that because OPS has been.
Cannot say your discussions we have seen.
Yes, ma'am. That
So
was the
according to you, it is not material.
And government had to submit a proposal. Government had to submit a proposal before the OPSC. OPSC may accept it because first proposal was.
Yes. All this we
The
remember.
wanted to do something.
Well,
Before doing something under the constitutional scheme, it was required to consult the commission.
yes, ma'am.
It consulted the commission. That you have established that the state government, before making amendments, had consulted the commission. Irrespective of the opinion of the commission, the state government could have, if they had it been the intention of the government, like in the previous case. In the previous case, the OPSC had opined against the proposal. Despite that, the state government could have amended the rules. It is not that the commission's opinion is binding on the government.
No, my lord, that was misplaced before the cabinet.
Misplaced, therefore, it was not placed. That is a different thing.
Yes.
But cabinet could have, after having taken note of the opinion of the OPSC,
Yes. They could have taken a government
Taken-
even contrary to the opinion
Contrary
of,
to the
yes, my lord. But in that
these communications are just to establish that there was effective consultation
consultation.
between and OPSC.
Yes, ma'am.
The question is different. The question is whether, and again, you will have to answer from that, 2003 rules.
Yes, I will come to that. Yes, ma'am.
So that is,
Yes, ma'am.
these are
Yes, ma'am.
very, very.
Your lordship see the 2003 rules. Yesterday, your lordship has seen that 2003 rules.
Limitation law. Services which can join.
To 2003 rules, you may have to argue that whether those rules apply or not.
Yes, that rule applies.
If that rule, if those rules apply, then because he was referring to classification control appeal rules. So this is how the services have been classified.
Yes.
So if that violates 2003 rules, then
Your lordship see that that rule your lordship has seen, that is not that amended rule. Your lordship can find it from page 258 of this book, my lord.
Could a CCA, na could
C-
what
CCA
is
rules.
that? CCA rules.
not CCA. Let us see.
No, that 2003 rules,
It's
that
there in
page.
the compendium.
Where
Yeah,
that
yeah,
compendium? Oh, dear. Bunch of-
Page,
258.
what is the name of the rules? Because here. the
Odisha
page-
Civil Services Criteria for Selection for Appointment, including Promotion Rules 2003.
Compilation कर दिया था ना? Yeah. Okay, भाई, ये reference. Compendium contains.
वैसे compilation का मतलब ये काली जोटा नहीं होगा।
Compilation खाली दिया है ना?
नहीं काली नहीं होगा। तब 10 आपको दला।
Give both.
Let's get it.
Yeah.
The lordship says Rule 3.
Yeah.
The Commission, Odisha Staff Selection Commission, Odisha Subordinate Staff Selection Commission, Selection Committee or the appointing authority, in case where such bodies do not exist or do not exercise their duties, shall for the purpose of initial appointment to any service post prepare a list through a competitive examination containing the names of successful candidates equal to the number of anticipated that year. Provided that in case where the list contains less number of success than the vacant entities, the regions of such shall be recorded in writing by the recruiter. In case a proposal from approved for filling of the vacant are not received in due time, the recruiting agency shall initiate recruitment every year for each cadre basing on the anticipated vacancies based on retirement, creation of the post otherwise, and promotion as per the provisions of the respective recruitment rules on obtaining information so and so. So they have to conduct the recruitment in accordance with the respective recruitment rules, my lord.
What else do you want to say?
They will conduct a recruitment in accordance with the recruitment rules.
Where is that?
LSP 3A, plan of examination.
3A.
LSP is looking at the new
2023 rules.
that LSP see this book. That amendment is not there, my lord.
What a minute, we have one book.
3A,
Sorry.
258.
Okay. The capital A, 3A.
My lord.
So what do you want to say from this?
But they are to conduct recruitment in accordance with the recruitment rules. Respective recruitment rules.
So which is the recruitment rule?
Recruitment Odisha Engineering Service rule.
Yes.
Yes, in that Odisha.
So in that rule,
If your lordship will come to that first 2012
You will have to read that with Rule 5.
yes, that has overriding effect. That they will conduct the recruitment in with the provisions made under the recruitment rules. If your lordship will see that 2012 rules,
No, please read the provision again, which you are read.
258.
Yes.
The Commission, Odisha Staff Selection Commission,
No, 3 we have read.
3A, the plan of recruitment. In case of proposals from appropriate authority for filling up the vacant posts are not received in due time, the recruiting agency shall initiate recruitment every year for each cadre basing on the anticipated vacancies based on retirement, creation of post or otherwise, and promotion as per the provisions of respective recruitment rules for obtaining information from the coordination rule 3B of this rule. 3B, the constitution of the coordination, there shall be a constituted coordination committee to ascertain the number of vacant posts authorized for recruitment consisting of the following members, namely. These are the coordination committee. They will intimate the number of vacancies each year to the agency, to either OPSC or Odisha Staff Selection, whoever the recruiting agency may be. So they will follow the recruitment rule.
Where is that?
Yes, LRC, LRC recruit provisions of the respect. LRC got it.
See, this 3A is for a different purpose altogether. Whereas 3 contemplates examination, written examination as a process of recruitment.
No, my lord, that's a competitive examination. That LRC, that is a competitive
examination.
Yes,
all right.
not written exam. That's a competitive examination.
Competitive examination. Then come to 3A. In
Yes.
case of proposal from appropriate authority for filling up are not received in due time.
Yes, my lord.
So for that limited purpose.
Yes, my lord. If both are, if proposal is received, but first, if the proposal is received, then 3 covers. If proposal is not received, then 3A covers. If the proposal is received, 3A covers OPSC or staff selection, whoever the recruiting agency shall conduct a examination, competitive
you
examination.
mean to say if they are asked?
They are asked.
If the OPSC asks, then they will conduct.
Yes. May I read again, my lord?
Same service, there cannot be 2 methods of recruitment. Therefore, 3 and 3A refer to the same.
If the appropriate authority sends a proposal in
Yes,
time.
but if your lordship will read 3 and 3A,
Exactly, reading both. So we are saying
that OPSC or recruiting agency cannot adopt 2 procedures for the same vacancy. Suppose a requisition is suppose a requisition is received. Suppose a requisition is received and requisition is not received. Recruitment is one.
Sir, the rule 3A stipulates that even if there is no requisition,
Yes.
the recruitment process can be undertaken.
Yes,
All right.
yes,
The
ma'am.
recruitment process can be undertaken on the basis of retirement, creation of posts, otherwise, right? What kind of rule is this? Unless there is requisition, where is the question of recruitment?
No, it's so but 3.3, yes, ma'am. 3.3, if a lot will read 3.3a together, 3 in respect of if requisition is received. 5.3a is made my lord, the allotment from 3b.
No, there's one thing, requisition received or they do not exercise the jurisdiction.
Yes, but that time, suppose requisition is received, enter intention is to fill up the post in due time. What I have understood from this 3 and 3b.
You cannot exclude 3.
No, I can, that I am saying that it can be read together, man. I cannot exclude 3 because 3 is the selection, how allotment 3 gives the power to the recruiting agency for recruitment. And the procedure laid down in that recruitment rules to be followed in case no requisition is received.
But that is even if there is any rule, even if there is any rule,
Yes,
Mr. Kotia,
my lord, I'm
which is contrary to which is not in tune with this rule 3.
my lord,
that
I am
actually
explaining 3. Why they have to follow the, when that requisition is made, in that requisition they have to mention the appointing authority mention the which recruitment procedure is to follow in accordance with the which rule. Because in that requisition itself, there is a that this in the appointment will be the recruitment will be made in accordance with this rule. But where no requisition is received, so they are bound to follow that recruitment rule.
otherwise they are not bound.
No, in a requisition,
If this interpretation is given, then rule 3A refers only to in case of proposal from appropriate authority are not received.
not received 3A,
Not received, then 3A will apply.
3A.
And if then in that case only 3A applies, then for other cases the recruitment rules will not apply.
No, my lord. In that requisition, they mention the appointing authority mentions the number of vacancies and the recruitment rule is to follow in that requisition.
Which requisition?
Where the requisition is made to the OPSC.
Under rule 3.
Yes, because in that requisition part, they meant the appointing authority.
Mr. You are right. They will say that this is the
Yes.
rule which is to be followed.
Yes.
But if the rule which they are suggesting is contrary to rule 3, then what will happen?
Then 3 will prevail, my lord. If a rule, because this has the overriding effect and in accordance with rule 5.
See, you are right that if the rule had it been a case where the rules provided the civil service rule that it will depend on the respective rules. It prohibits framing of the rules contrary to the provisions under the rules.
But
All right, for appointment to state civil service posts. 3 and read with 5.
3 is, perhaps there is no.
One moment, Mr.
Just think of this situation.
Yes, my lord.
If the rules, if the respective rules are to be applied only in case of 3A.
No, my lord. No. That is applicable in.
You are right.
Yes, my lord.
You are absolutely right that rule 3 will apply for all other rules will have to be accepted, which are in accordance with rule 3.
Yes,
So,
my.
The rules must be in accordance
with rule 3. Yes.
Your rule. So that is the challenge.
There is no yes, my lord. That there is no dispute that no rule can be made in contravention of rule 3. What rule 3 says, the selection shall be made by
competitive examination.
Yes. So in the 2020-22-23 rules, my lord, that we are saying that competitive examination, the viable test is a competitive examination.
Yes, you can say.
Yes.
Take this plea. Take this plea.
Yes, that I want to submit that in that 10%, because earlier you were 100%.
Yes.
There was no competitive examination. In 2021, that amendment, There is no competitive examination.
Why are we going to 2020?
At that time, but so far as 2023 is concerned, there is a competitive examination of 10 marks.
The interview,
no.
the interview you are saying is competitive examination.
Yes, examination.
So if you are saying that to be the competitive examination, there is difference between comparative evaluation and competitive examination. You will have to work out on this. What is the meaning of competitive examination? Here, there is an examination which is not held by the BPSC. Sorry, OPSC. It is held by
GATE.
GATE. So according to you, you may say that is also a competitive examination.
No, but yes.
The meaning of all right.
And the 320 examination.
Yes.
320 says only examination. Article 320 says only examination.
Every examination is
Yes.
competitive examination.
Competitive. That is, every examination is a competitive examination. There is no dispute.
Yes. Then
Then they have relied upon that judgment of the Patna High Court. And this is I have said, my lords, that proposal has been received, that consent of the OPS has been taken, and that rule is in accordance with the procedure laid down. So there is no, then my lords, notice to that Patna High Court judgment, mostly they have relied upon that Patna High Court's judgment. And before that, my lord, I will draw my lord's notice to that GATE. Then I'll bring to my lord's notice that GATE brochure. That was filed in WPC number 42059, filed by Penal Counsel Mr. Palit.
yes.
Let's look at it. That your lordship said page 28.
No, that GAT brochure is an annexure or filed
No,
later.
in the document relied upon, she has filed a document relied upon. WPC number 42059 of 2023. Yesterday, he has filed that compilation.
Yes. Page 11.
Page 28. Because I will not.
Starts with 11 page. Okay.
Plus, you got opportunity with GATE examination. You also got it. That fourth paragraph, your lordship.
Yes.
Several public sector undertakings. Fourth paragraph, page 28, my lord.
28.
Opportunities with gate qualification.
No, that is not the question. The question is, the question is that if today this has no statutory.
No,
backing.
that I want to draw my lord's notice
I
only.
want to draw something else. If this gate has no statutory backing,
No, my lord.
all right,
No, my lord.
it's a body which conducts examination. Now, tomorrow, if the body is dissolved, your this will become inoperative.
Yes.
How can you have this kind of all right, now you
Yeah,
can
hello.
refer-
Direct recruitment to Group A level posts. Fifth paragraph, my lord.
Yes.
Direct recruitment to Group A level post in the central government, such as senior field of telecoms, senior research officer crypto, and senior research of SNT in cabinet government of India is now being done based on gate score.
So why have they mentioned? Why have they mentioned?
This is the opportunity to the gate who are appearing in that gate exam. What is the opportunity?
Why have they mentioned?
Yes.
Why was it required? Because it was constituted for this purpose, general information, graduate aptitude test in
Yes.
engineering, and then they say this, and then they say this also. So what was the requirement?
No, I want to say that because this what is my other
More and more candidates may participate in the
Yes.
examination with a hope that the gate score can be considered for the
recruitment
employment also.
Yes.
Therefore, more and more candidates should participate in gate examination and pay fee for that.
Yes.
All right.
Yes,
So
but
this is a kind of
Advertisement.
a kind of advertisement by gate.
Yes. Yes, ma'am. So my submission that their submission is only gate examination, not for only higher education. It is also for the recruitment. In that, I want to establish that.
See that gate examination. Therefore, we are saying that gate examination is held by a body which is not statutory.
Yes, madam.
So tomorrow, if suppose there is another examination held.
Yes, madam. In place of gate, another examination will be conducted.
In place of gate, not in addition to gate. That is held by some other body. Then you can say that the score in SAT.
Yes, ma'am.
SAT can be basis. You can have this also. The GRE will be
Cat in this country is cat.
CAT for civil service. CAT is also that conducted by very authentic agency. And then GRE. Very difficult. And you can do that. You can do that. You have the rule making power. You could have amended.
Asking yesterday, they have different papers for the consultants.
And you don't define what is gate.
The definition chapter, madam.
There is nothing. What gate?
in that 2021 rule that we have said that gate
2021 is no more.
in 2023, my lord. Gate,
Given the full form also.
yes, that has been written. Yeah, Lord, three.
Page 170 and extra.
Definitions.
Page 170 is the brief. Brief in 170.
So that 2023 rule that the commission after receipt of shall take step to select on the basis of valid graduate aptitude test in engineering. That is GATE. And that is the definition of GATE.
Gate held by which is when you define your state government, government means state government of Odisha. Appropriate authority means, so you define these things.
And only this is the definition. Yes, in definition chapter, there is no definition of GATE.
Definition chapter, there is no definition.
In definition chapter, there is no definition of GATE.
May not be required if you have explained that.
But
If a
yes, ma'am,
particular thing
that has
has
been
been
explained. Yes, ma'am.
Somewhere, if had you explained somewhere that gate that is held by so and so, so and so. But even that, see, your recruitment rules should not be for 1 year. Therefore, an example.
Yes,
that
ma'am.
this has no statutory backing, and you are depending on this examination. Tomorrow, the gate may be abolished, so your rules are abolished. And the rules are abolished, and then you frame another rule. And your submission that the concept of gate was introduced in 2021 itself, and therefore they cannot take the plea now that 3 years opportunity was not there.
Yes, ma'am.
That rule was struck down.
Now it's not 3 years, 1 year. This is not 3 years. That earlier was 3 years. Now,
What is the difference between 3 years and 1 year?
what are the 5 years?
3 years was for the benefit of such candidates who had taken more than one gate.
Best.
Best,
All right.
highest mark in
Those
3
who had
years.
taken, those who had taken more than one gate,
Yes.
they could have claimed their score, which was the best amongst
Yes.
the three. So if a candidate one score had appeared once, he could rely on that.
Yes, only
So
that.
it is not that 3 gate scores were required.
Yes, no, not 3 gate scores. That the highest gate scores is 3. By that process, by that rule, others, my lords are held, others were deprived of because they have not appeared thrice. The first time it was introduced in 2000.
All right. So therefore, 2021, you will have to forget that story.
Yes.
Because you have replaced that. You have replaced and you brought 2023 rules. In 2023, when you brought the rules, it could not have been presumed that you are again bringing that.
Yes, ma'am. Only we have
Right.
said that is valid gate score.
Valid gate score, and then your rules will have to be considered as if they were framed in 2023.
Yes, ma'am.
23.
23 only.
It is not that because it was introduced in 2021 itself, therefore the students would have started participating in the gate examination. That cannot be accepted. Once you, if we accept your submission, that the gate could be a valid this thing, process for determination of comparative merit, then you could have given opportunity for the
Candidates.
aspirants to participate in the gate examination.
Yes, madam. That may be a ground for quashing of that advertisement. That may be a ground for quashing of that advertisement only, because not the rule.
Very good.
Because
Very good.
I understand
Correct,
I understand that, but if suppose they are not, I am submitting.
Absolutely right. You are absolutely right. That can be if we uphold the gate examination.
Yes,
Then the advertisement can be quashed.
yes, because they are not given sufficient opportunity, because that rule was framed in 2023.
Absolutely right.
So after 4 months that advertisement is made,
Yes, yes.
they are not given that adequate opportunity.
You are right. That cannot be a ground for
Quashing the rule, that
Yes. Yes.
that can be ground to quash that advertisement.
Right.
Yes.
Right.
And have you checked if enough opportunity was given or not?
No, but that in fact, if that time, if you also will say
We're not
that,
saying if. Have you checked if enough time was given?
in fact, enough time is not given, because
Why?
why that 2000 you also have seen that rule to 170,
No, tell us why.
that 4 months gap was there.
What for?
If you also
Last
will,
date for applying for GAT, have you checked?
yes, madam,
What was it?
7th October. Extended that fine with fine 7th October, 29th, perhaps that was the.
You showed us the GAT papers. From that, we found it has been extended to 13th October.
As that 7th, I am saying that because of, no, madam, yes, we
Earlier
have
it
to
was
take,
30th
no, madam, yes,
September.
we have to take the marks of the gate score. Those who have appeared, suppose one has appeared that during that examination period, his score cannot be taken into account as the last date was fixed after the examination, before the examination. By that process, some were deprived of that, I don't dispute to that effect.
We are not.
If he has appeared, but the examination, the result is not published.
The result usually is published in February.
In here, perhaps result is published after March.
March. Okay, that was same thing.
So that I am saying that
All right, got it.
by that process, some of them were deprived, because if your lordship will say that gate one is eligible when he is prosecuting his study in 3rd year.
Yes, yes.
When he is prosecuting in 3rd year, he can appear in the examination.
Yes.
Not the
But
question.
that, yes, I understand, because in that rule we have provided that we'll adopt that gate score.
All right.
So when first time one came to know, if 2023 rule is taken into account,
Not enough time to appear and
Yes.
get a score.
yes, ma'am,
Yes, got it.
that is a ground made to quash that advertisement.
Got it.
Yes, you are right.
Second aspect, my lords, notice that Patna High Court judgment where that how that is distinguishable. I'll no.
Madam, there's no chair for you. You've been standing since yesterday, I think.
Yes.
Well, Patna High Court judgment is at page 209 at Annexure 11.
Yes.
Well, there were on 3 grounds it was challenged. First ground was that was contrary to the eligibility criteria fixed by AICT. Second, is the condition for admission to postgraduate course as the petitioners are postgraduates, they are deprived of their selection. Third, amendment is contrary to the rule in so far as evaluation of candidates on their work experience and teaching skill is concerned.
Yes.
That their rule, LRC is page 218.
Yes.
These are the grounds that hasn't reflected in that part. Let's we got it page 218.
Yes, please.
This deviation, according to Mr. Singh, is contrary to the rules. So also the eligibility criteria fixed by the All India Council for Technical Education herein after referred as AICT, a copy of which is included at Annexure 6 to the writ petition. Learned Council has referred to entry 66 of list 1 to submit that the field of coordination and determination of standard in institution for higher education or research in scientific and technical is reserved for the Parliament, and though 25 of list 3 of Schedule 7 to the Constitution empowers both union as well as the state to legislate in the field of education, including technical education, but such reservation is subject to the provisions of entry 64, 65, and 66 of list 1. He thus submits that while the AICT has laid down the eligibility condition for appointment of lecturers, which has parliamentary sanction under entry 6 of list 1, the rules framed by the state legislature in exercise of jurisdiction of under entry 25 of list 3 has to be in tune and subject to the rules framed by the AICT and cannot be in conflict thereof. First ground. Second ground, my lord, page 2221.
Yes.
Last paragraph. It is the admission of Mr. Singh that passing of gate is a condition for admission to postgraduate course, but since these petitions are already postgraduates, they are not required to pass such examination. It is the submission of Mr. Singh that it is by virtue of such illegality committed by the state in its Science and Technology Department that the petitioner are eligible for appointment as per the eligibility at table 1, appendix 1 to the at annexure 8, but they are deprived of appointment as so and so. These are the second ground. Third ground, my lord, that amendment is contrary to the rule insofar as evaluation of the candidates on their work experience and teaching skill is concerned. Your Lordship may say that page 226.
Yes.
Your Lordship may say the weightage scheme as its original existed in table in appendix is concerned provided as follows. Cadre post academic record and research work. Evaluation of work that that term was used here in our rule, that is written test. Here evaluation of work knowledge and teaching skill.
Mr. You are want to say that these rules were in relation to teachers.
Yes, teachers and
Here it is, here
engineers. But in that judgment that they have seen that shown that they were deprived of, because they are postgraduates, they cannot get, and by this introduction of the gate, they are.
No, cannot is not the right word. They need not.
They need not. Sorry, they need not. So they are deprived. Sorry.
See, there was another aspect also. You can distinguish that decision with, no, not with it, because there the court was dealing with appointment of teachers.
Yes, yes, ma'am. That teachers in the polytechnic colleges.
Technical colleges. So and that background, the court remarked that the skill, the teaching skill,
yes,
was required to be tested. That could not be tested through gate. And this is how.
Yes.
So this, you can distinguish that.
Yes,
that case
yes.
on that ground. But that was not the only ground. The other points are there. And after all, that judgment doesn't bind us.
Yes. Only viabus is taken into account whether it amounts to a competitive examination. That has been held in that Honorable Apex Court in the case of judgment. 1981 4 SCC 159. Paraf.
What is the name?
Liladhar versus State. Lila. I am giving that.
Yes.
Oh.
Yes. Para 5.
Para 1 ରୁ ପଢନ୍ତୁ।
It start Election is
Yes,
from the beginning, election.
yes,
What is the ideal mode of selection to a public service by written examination, by oral test, or by a combination of both? If the last, what is the proper relative weight that should be attached to the written examination and the oral test? If the oral test so pernicious in practice as suggested by some, that it should be abandoned without regrets or weight, or the weight to be attached to it to made minimals. Has any such consensus emerged among the informed and the consistency to require the court to scrap a selection is arbitrary on the sole ground that weight accorded to the oral test appeared to be high? By para 3M. 3. Sri Marital and Counsel for the petition read two principal contents before us. The first was that entire selection was vitiated by allocation of 25% of the total marks for the viable examination. The submission was that the allocation of so high percent of marks for the interview an irremediable element of arbitrariness so as to offend Article 14 and 16 of the Constitution of India. In support of this submission, reliance was placed on the decision of this court in Ajay Hasya versus Khalid Mudi Sarwar. Sri Mehta's second contention was that marks were awarded in the interview test in a single lot instead of subdividing awarding marks separately under various heads for the various matters tested in the interview. Reliance was placed on A. Terry Kuppam Chattiar versus State of Tamil Nadu. The object of any process for entry into public service is to secure the best and the most suitable person for the job, avoiding patronage and favoritism. Selection based on merit, tested impersonal object is the essential foundation of any useful, efficient public service. So, open competitive exam has come to be accepted as the great way to public service. The ideal is to do with unfairness. The competitive exam were the answer to the twin problems represented by the democracy and the requirement of good administration. They were the means by which equality of opportunity were to be united with efficiency. By this means, favor were to be excluded, and the goal securing the best man for job was to be achieved. Open competitive exams are a peculiar democratic institution. Any qualified may come forward. His relative competence for the appointment is determined by a neutral, disinterested body on the basis of objective evidence supplied by the candidate himself. No one has pulled, everyone stands on his own feet. The system is para 5, that is important. It is now well recognized that while a written examination assesses a candidate's knowledge and intellectual ability, and interview is valuable to assess candidates' overall and personal qualities. While a written examination has certain distinct advantages over the interview test, there are yet no written tests which can evaluate candidates' initiative, alertness, resourcefulness, dependentness, cooperative capability for clear and logical effectiveness in discussion, effectiveness in meeting and dealing with others, adapt judgment, ability to make decisions, ability to lead, intellectual and moral. Some of these qualities may be evaluated perhaps with some degrees of error by an interview test, much depending on the constitution of the interview board. So and so any form of any form possesses certain administrative advantage over oral and performance. The written form is much easier. So and so, but in this case, that viable test is a competitive examination. It has been held. So that might ask that question whether viable test is a competitive examination or not.
all right. If viva test is competitive examination and
For the purpose of 3 only, I am explaining that purpose of rule 3 of that 2003 rules.
how much weightage are you giving?
10%
And 90% on
get score.
what is that?
Page 167.
So viva voce is the form of examination,
Yes.
right? And then 10% weightage is given on then that circumstance. What is gate?
Get score that I have said that
It is also an examination.
it is also an examination conducted by anybody else than OPSC. It is
You
the
cannot say that
not
because the examination is a function of the OPSC.
yes, ma'am. That I am saying that
So therefore, you say that that is the examination within the meaning of Rule 3.
yes, ma'am. No, that I want to say, my lord, that we are taking the score secured in that gate.
It is like if you can decide that that is done also, that you will prepare merit list on the basis of their respective scores
The expected scores.
in the engineering examination.
That was
All
there
right.
in 2012.
And you will prepare merit list accordingly. The 90% of the weightage shall be given to that, the university examination, the whatever, and 10% for interview.
Yes.
So there you are just replacing at with gate, which according to you is has maintained sanctity also so far.
Yes, ma'am.
Strong argument.
As the best institution now. It is the state government who feels that it is the score of a gate which is the best institution, and therefore it is the domain of the to decide that what could be the
Not the domain of
eligibility
Mr.
and
Let him complete.
like,
Anything else?
No, my lord. So far as the virus is concerned, I'm saying there is no alternative because that we have adopted it and taking into account the examination conducted by the gate. Because the intention to select the best.
The question is what the OPSC is doing.
Yes, my lord. Here, my yes, my lord. Here, my lord, we have provided OPSC 10 mark only, 10% mark.
Who are you?
The state, this the
Yes, the state, the duty of the function of the OPSC to conduct examination or test. You have framed a rule where you have excluded the function of the almost excluded, except for that 10% of interview.
well, earlier in the earlier rule, we have given only 60%.
See, whatever observation we are making, it is not that is our
No,
opinion.
no, my lord. Yes,
We are
my
also in the
yes,
the process of thinking. We are developing arguments and counter arguments. Also.
yes, my end.
So just think of this situation that PSC has the responsibility, constitutional responsibility. By framing rules, you have given the OPSC function to make recommendations, but examinations shall be conducted by someone else. You don't rely on OPSC, and then 10% viva. So what is the role of OPS?
So that examination part is concerned with it is the admitted fact. There is no dispute. We have conferred with only 10% of the total mark.
So therefore, you can frame rules in a manner.
And in our while making the rule, in our opinion, we can get the best candidate if we choose from the gate candidates. That was the intention.
And you can get from
Best. That
other
our
services.
intention is to get the best.
For other services, you can get best from the
While framing this rule, this is the intention of the government.
intention of the government. But intention of the government may be very good, but whether it falls within the frame of the constitutional scheme is the question. All right. We are also not very clear as to what is yes.
Yes.
An interesting part is you made the OPSC happy with that 10%.
Because the incumbents get changed. Chairman of the OPSC gets changed.
No, that is different.
Yeah, that is changed.
So they have consulted. In fact, this is effective consultation.
and the review application can be allowed.
That's all.
Yes.
Yes. Who else has to understand?
OPSC. Yes.
Which are appearing for the Public Service Commission.
Public service, do you have to make any submission?
Just a couple of points, my lord. My lord, I will not take more than 5-10 minutes. My lords, may kindly have my counter affidavit, the counter affidavit of the state, annexure D by 1. The consultation that has happened. A submission has been made that the OPAC put down to the state government. My lord, I just want to address that point. The lordship sees page 25 of the counter affidavit annexure D by 1.
That we have seen.
Yes, ma'am. I just want to point out, my lord, in paragraph 1, they have referred to Article 320.
Yes.
The very question that fell from your lordship, that the OPAC has been completely deprived of any work whatsoever in the recruitment process. That is why we stated that yes, we should have 30% interview. Thereafter, we found a middle ground, and my lord, we revised it to 10%. We agreed with the recommendation. And my lords, in this context, I must also cite the judgment that my learned senior Mr. Khuntia just placed in the judgment of Leeladhar. In Leeladhar, the honorable in Ajay Hasya case, a constitution bench of Supreme Court said not more than 15% allocation towards interview. In Leeladhar, in that judgment, the honorable court has said that that portion of Ajay Hasya is per incurium insofar as public employment is concerned. And court has, however, the trend of judicial pronouncements is that there should not be disproportionate allocation towards interview. That is my submission on that point, my lords. And for that matter, my lords, 10% is good enough to for recruitment in the present process, my lords.
Wasn't that Leela challenging that 25% to be too high? Court said it is all right.
Court said it is all right. Court said it is all right. Then, my lords, will kindly have annexure 1, page 45 of the writ petition, which is the 2012 rules. But there are various rules in the state. Various recruitments happen on the basis of where career marking is a part of the recruitment process.
Absolutely right.
And in fact, the first rule, the 2012 rule, allocated 50% towards career marking. And that 50% consisted of high school certificate marks and degree in engineering marks. But all these three examinations are conducted by third parties. All these three examinations are conducted by third parties, and these marks are adopted by the OPSC for the purposes. So therefore, career marking can also be a form of examination, can be a part of a recruitment process.
Your submission is that for any recruitment process, it is not mandatory that there should be one competitive written examination and the other.
Well,
all right, this is your submission.
Yes, ma'am.
So based on so many things like experience, like marks obtained and the university examination, school examination, that can also be taken into account. The main role of the Service Commission is to recommend.
Your Lordship, please.
Based on comparative evaluation of the aspirants.
Your Lordship, please. Yes, ma'am. And last one point, my lords. The 2023 rules were gazetted on 30th of September. And we published an advertisement on 28th of December. And we stated that gate scores which have been published after 28th of December, after the last date of publication of after the last date of online applications, they will not be considered. Therefore, we are not considering GATE 2024 as a valid GATE score for the purposes of the advertisement under challenge. Your Lordships may ask, your Lordships have asked whether you have granted enough opportunity to the candidates to have to get a shot at the examination. But my submission is Rule 1 of the 2023 amendment says that this rule comes into force from the date of its publication in the Gazette. It was published in the Gazette on 30th of September. Rule 1 has not been challenged in the present case. Therefore, the 2023 amendment has come into force. Once the 2023 amendment has come into force, the Odisha Public Service Commission, upon receipt of a requisition, is bound to follow the method of recruitment in the 2023 amendment.
Right.
There may be enough candidates in the market, available in the market, so that enough people actually apply. Tomorrow, as an illustration, if I may say, tomorrow if I make an amendment increasing the eligibility criteria from BTech to MTech, or say I add a criteria, add 2 years of internship, can the petitioners come up and say that, no, you have to give us a chance. You wait for 2 years after publication of the rules. Allow us a chance to participate in an internship and then we will come. If there are enough candidates available in the market, then the rules are not arbitrary. Advertisement is not arbitrary. That is my submission.
Take another example. Suppose you suddenly reduce the outer limit, age limit. Then persons who have been waiting to take the examination, they do not have a chance to appear in the examination.
Yes, my lord. And in fact, a division bench of this honorable court has this very same thing had happened in Odisha, and the division bench of this honorable court has stated that age relaxation is a policy decision of the state government.
But I think, if I'm not mistaken, they were given a chance to appear.
In
That
this
must
case,
be another
in
case.
this case,
No,
when the earlier writ petition was challenged before the Honorable Supreme Court has taken that order of placement. They say they will be given opportunity. Those who have applied in the earlier advertisement, their overage will be considered.
Now that is a different.
That is.
Well, just one last point. Why there was a rush in publishing this advertisement on 28th of December? In the Supreme Court, when the matter was disposed of as infructuous, there was an observation made that candidates who had applied under the earlier advertisement, which was quashed, they will not be allowed to be debarred on the ground of being overage. For that reason, we had to publish the advertisement in the same academic year.
Why?
So otherwise, the next academic year, as per the rules, they will become overage.
But you could have permitted appear.
As per the malice, then it would have required further amendment.
Okay. You already amended it, and then the decision of the Supreme Court came.
Yes, ma'am.
That is why the hurry to publish the advertisement.
Yes, ma'am. So that those persons do not become age barred who had already applied. Grateful.
Yes.
These post cases, my lord, I have appeared for some candidates, those who have appeared, I filed an international application in all these cases. I have a very limited scope. I know, my lord, my limitation. But only thing I will state whatever friends here. My lord, this gate has been accepted, not by the state as a first occasion. Gate has been accepted by different government organizations or the other governments also. I have got these notifications. So far, Madhya Pradesh, Uttar Pradesh, and also a central agency like that Bureau of Investigation. They've also adopted this gate as a parameter for selection of candidate, because gate is an examination widely accepted because it has been conducted by very reputed institutions and it is a national examination. If this 90% examination, what the PSC was doing, my lord, prior to this gate, they were conducting examination locally. All this examination was concentrated to these candidates of the state of Orissa, and they're getting. Now they're getting the better candidates if there's a national examination. And the gate score, there is no pass mark, my lord. The gate examination, what is the parameter of fixation of the mark? Every time it differs. So for the UR category candidates, general category candidates, my lord, what they've done, the pass mark, the highest mark secured by the SC/ST candidate in that particular examination is the last mark of the UR category candidates. So that means if they go, the SC candidates goes up to 80%. Let us say out of 100. So our pass mark, suppose I am belongs to the UR category, I have to secure 80 plus. Then only I can get a score, my lord. Kindly see the parameter fixed by them. So these are the candidates passing from that national examination. And that is why the government has taken a decision, because other governments has also accepted this position. And they have accepted it. Though in 21 only on technicality, because there are no approval of the OPSC, it was struck down by my lord and it has now been rectified. So it is not a new thing. It's the first time it is introduced. And basing on this, I am obliged, my lord, I have got a judgment of my lords sitting in Bihar also. My lord of course accepted that point of view, because that latter judgment of that division bench what is referred to, but that is in a different context. But my lord's view, what my lord is now, we are now arguing before my lord, that is also, I subscribe to the view of my lord. I have got this gazette notification, can I give all this?
That judgment?
A judgment also I have given.
What is the?
Only thing, because yesterday
That is the advantage of my poor memory.
that is there. My lord, kindly have, if my lord will see the past, my lord will get it.
That I don't remember what I had.
At page 24 in that bunch, my lord. Can you see page 24, my lord's order? I've got it through net. Page 24. Serially, I will make it annex 3. I could not get a index, my lord. I will give you index, my lord. But next week. Page 24, my lord, can see.
But we get wiser every day.
Yes, my lord. That is always there, my lord. It is human being.
Okay.
But my response submission is the views taken by my lord.
Power holding company.
Yes.
What is the
Yes.
challenge?
This is directly on the issue with regard to recruitment, my lord. But what the other division bench of the Patna High Court says about recruitment of a teacher,
Teachers, all right.
that is the distinction, my lord. That is why my learned friend Mr. Khuntia has distinguished that. But this is with regard to recruitment. And my lord have taken all the points with regard to GATE.
But this is slightly different. Shortlisted on basis of valid score. Shortlisted.
But ultimately this honorable court has held this Patna single bench order. GATE is a valid method of selection or
Recognized.
recruitment of candidates. And this is a well-written order, my lord, that if my lord will permit, I have also marked it. I can read out everything. My lord have also taken note of Article 14 and 16. There is no violation. Because if somebody is questioning a virus of a rule, my lord, normally we have to satisfy the court that to which provision of the constitution it affects.
See, the fundamental difference between my decision in Patna High Court and the case which we are considering,
Yes.
that related to a company, power
Yes,
holding
yes.
company.
Yes.
And this is
Public.
state which has to consult OPSC in such matters,
My lord.
which requires constitutional requirement under Article 320 and then statutory provision also. We are considering that that aspect also when it says that examination, that of course it includes 5 hours. That is also a competitive examination. And so therefore, and the rules we had not noticed what is the effect of Rule 3 of 2003 rules.
Yes, ma'am.
These are
My response submission is so far that Rule 3 is concerned, my lord. Civil service recruitment, it deals with civil service recruitment. That Rule 3, 3A, B, C, D, E has to be read together. That is my lord's.
That.
So this, if we will read together, the end, as my understanding goes, my lord, the route is every recruitment has to be done as per the recruitment rule available for that particular post.
Still, with the only caveat that that rule must be in conformity with 2003 rules.
Yes, my lord. That my response submission.
Every recruitment rule, every recruitment, every cadre can have a rule to be for the purpose of filling of the post. Those recruitment rules shall be followed,
Right.
subject to the condition that those rules are in conformity with Rule 3. That is the question.
That is why, because he has read it, I don't want to repeat all these things. But what the rule says, the preface of the rule is Odisha Civil Service criteria for selection for appointment, including promotion, Rule 2003. The original rule, my lord, this Rule 3A and all these things were not there. The 2003 rule. This amendment come in 2015. This 3A, B were introduced to the statute, my lord. This rule qualifies what is the criteria of the selection. Because entire aim of the rule is to get the best from the lot. So to get it, they say, whatever the procedure adopted in a particular recruitment rule, because we have different cadre rules. Suppose for the civil service, that means, my lord, Odisha administrative service, there is a separate rule. For this engineering service, my lord, we have this rule. For other rules, my lord, also in Group A post, there are different rules. So that what it says is, if Rule 3 read with this Rule 5, that is overriding.
Overriding, they are challenging the rule, being contrary to Rule 3, with Rule 5 of the rules.
My response submission is, yes, ma'am. My response submission is, when the Rule 3 specifies that the recruitment has to be conducted by the OPSC in conformity with the recruitment rule for whom the recruitment is.
No, Rule 3 doesn't say that.
My lord, may I read it again?
Read it.
My lord. Rule, I will read out, my lord, 3A.
Just Rule 3. Read Rule 3. 3A is independent.
No, that is my
3B.
difficulty, my lord.
No, Rule 3.
Yes, let me read out 3 first.
3 capital A is because
No proposal.
no, otherwise it would have disturbed the seriatim of the numbering.
My lord.
So had Rule 3A been Rule 4, Rule 7 would have been Rule 8. Therefore, after Rule 3, they added Rule 3A
Yeah.
and then Rule 3B. So 3A is independent provision.
Let me.
And it deals with a particular situation.
My lord.
When the proposals are not sent.
My lord.
Where OPSC conducts examination on the basis of proposals, requisitions sent. The pause.
My lord.
Now, that 3A contemplates a situation when there is no proposal received from a department.
My lord.
When even then, the OPSC can conduct the process of recruitment, can hold the process of recruitment. This is what 3A says, in accordance with the rule.
My lord.
But those rules, whichever rules, must be in conformity with Rule 3.
Yes, ma'am. So let me read 3 first. Initial recruitment. The commission or Odisha Staff Selection Commission, Odisha Subordinate Staff Selection, Selection Committee or the appointing authority in case where such bodies do not exist, that is a comma, or do not exercise their jurisdiction, comma, shall, for the purpose of initial appointment to any service post, prepare a list through competitive examination containing the names of successful candidates equal to the number of vacancies as anticipated pertaining to that year. Provided in case where the list contain less number of successful candidates than the vacancies anticipated, the reason of such shortfall shall be recorded in writing to the recruiting agency, by the recruiting agency. As
independent.
Independent, yes, my understanding, well, maybe wrong.
3 cannot be read with 3A.
No, I am just 3 I am reading out.
Yes.
My lord, what does it say, my lord? Kindly see the preposition used here. The commission means, my lord, OPSC, Odisha Public Service Commission, / Odisha Staff Selection Commission, / Odisha Subordinate Staff Selection Commission. These are the 3 agencies available in the state. Selection Committee or the appointing authority in case where such bodies do not exist. Any authority. Suppose these 3 bodies is not there. Any other agency do not exist.
Agency, the appointing authority. No other agency.
The selection committee or appointing authority. Appointing authority. Or the appointing authority in case where such bodies do not exist. This is with regard to my understanding. Understanding, well. Maybe I'm 100% wrong, but subject to approval, my lord. What I understand this is, if these agencies, not the selecting agencies are not there, what the appointing authority will do? The appointing authority will prepare a list of candidates through a competitive examination containing the numbers and give them appointment. This is the power under 3 is to the appointing authority. When these bodies are not there, but when the bodies are there.
These bodies are not there. OPSC, without OPSC, the constitutional scheme shall not operate, because for those posts, the OPSC has to exist and the OPSC has to make recommendations. No appointment can be made.
That is there, my lord. But this contingency, this rule has taken, as my understanding is.
This contingency is only in respect of other selection boards or committees or selection committees.
Yes, my lord. So now this 3 is not available to be adjudicated in this particular case because there is OPSC and there is a requisition. And therefore, when the question comes to the OPSC, then now my lord, question is, what is the criteria of selection? OPSC. My response submission would be, the OPSC has to perform the recruitment in consonance with the recruitment rule for which the recruitment meant for. Here the recruitment is for engineers.
That is not the question. The question is where the recruitment, they have a duty to follow the recruitment rules.
My lord.
Therefore, they are following the recruitment rules. and therefore there is no illegality.
Minor.
They are challenging the rules.
Yes, that is why I am saying.
And they are challenging the rules on the ground that it is in conflict with the rules of 3, which has overriding effect.
Mine as per submission is overriding effect if you read that plus 5, rule 5. What does it say? Only overriding if it conflict with this rule. But mine as per submission, there is no conflict. Kindly see rule 5. Overriding effect. The provisions of these rules, this means this total 3 rules, shall have overriding effect notwithstanding anything to the contrary contained in any other recruitment rule for the time being in force. If anything contrary to this, now there is no contradiction taken by the OPSC or by the government, according to me, because they are now going for a selection as per the recruitment rule of 2012 as amended in 2023.
Right.
And that is why they are not processing. So where is the mistake in introducing 7.3?
All right.
That is all about my submission, madam.
Okay.
And my lord, there are good number of candidates we have also applied for. For this, we have passed, scored the gate. As per our scoring, my lord, we have applied, we have a hope that yes, we will be selected. But because of all these cases, we are now suffering. That is our obligation.
Everything has been already.
I'm also appealing on behalf of some intervener minors in 3 of the 8 petitions. Because my submission will be very short, minors, and 3%. Minors already raised 3 points. Yesterday, minors have got down 3 points. Minors, I have to answer all the basis of those 3 points minors raised. First, minors, I will refer to the point. Yes, sir. Whether they have got adequate opportunity to appear the gate examination. In this context, I will bring to minors' notice a particular document, a press release, press brief. That would be, I think, minors, to my humble contention, it will be required and it will appeal to minors' conscience to appreciate that way back in the year 2020, the government made the people, student conscious that we are going to do that. You appear that examination and make yourself ready. That document is not probably forthcoming. I took a, I got that document because I couldn't file, intervener, I couldn't file any document in this procurement. So I'm referring to some document final practices.
Press briefing by whom?
Press briefing government.
Government where?
Department of, G department, I think. That I got it with difficulty.
Please don't refer to those. Please don't. We are deciding constitutional issue. And you are relying on some press briefing before the rules were framed.
I'm coming to that. I'm coming to that.
Please make your submission.
Only that will be one point. Then I will go to another points. Well, sir, kindly have a glance that press briefing for my request. Is my request, minors. There, the government has categorically stated that we are going to introduce gate.
Mister, we will not. Please.
I understood that what minors says. I understood that. I realized
us to hear what you are saying.
Yes, minors. Thing is that now this second contention. The second contention is that minors, my humble contention so far that they have got adequate opportunity or not. From 2020, you know that yes, gate is going to be introduced. 2021, the new rule has come. Of course, the rule has specified that 3 years criteria. 2021, you got an opportunity to appear. 2022 minors, they got an opportunity to appear. 2023, they got an opportunity to appear. But 2024, minor, of course, it has not matured, minors. No, and that's not matured because they are now the thing is that the examination would be in the month of February, result would be in the month of March, but before that, the advertisement has come. Result 2024, result has not come. So the 3 years, they have got opportunity. Now, minors, the change, the whole total change, minors, so far that the 21 amendment and 23 amendment, minors, that categorically, minors, if it would be minors read as a whole, that earlier amendment, it required that 3 gate score, 3 for 3 years, Plus out
Right.
of that, whichever the best.
We are putting one question because you are repeating the same submission which has already been discussed.
Yes, madam.
Why are you repeatedly saying that it was in 2021 itself in the rules that the GATE examination had become compulsory? On what basis you are saying this?
GATE examination is compulsory, madam.
No, GATE score.
GATE score.
GATE score for this recruitment had become compulsory since 2021, or there was an indication.
Yes.
How do you say?
But the thing is that man kind of a glass 2021 rule. 2021 rule say
2021 rule has gone.
but that has been humble contention that you are aware of all these and you could have, because GATE is not minors, that because of you will appear the examination, that is what is not required. A student will must upgrade his career minors to have a postgraduate degree or to get an appointment in corporation and that he can appear. He has got an opportunity to appear, but he has not appeared. Then now question comes, he is now stalling over this case. Suppose kind of visualize one thing, minors. Some people, those who have appeared GATE examination, they have already applied for this post and they may be selected. Next year, minors, many students, they must be appearing the examination and they must be minors selected. And thing is that minors, then if the vacancy will come up and they can also apply, they can also get compete and they can be selected also. Thing is that in this contest, minors, what my humble contention 3-4, first is that my honorable court has pointed out the word GATE not defined. 3 points minors have pointed out.
We accept you that GATE has been defined. Proceed further.
The first point is that. Then the second point minors have pointed out state civil service rule minors. My learned friend minors have already pointed out. I need not want to repeat it. Thing is that 3 and 3A must be read harmoniously minors. Once recruitment rule, it should be read harmoniously to come to a conclusion. Ultimately, minors, the thing is that the examination will be held under the 3A. 3 is concerned, not 3A. 3A will be here, and under 3, this examination going to held. But in this context, may I point out one thing? So far as the recruitment process in Odisha is concerned, there are various recruitment rules concerning different, like medical examination, like agricultural engineering examination. They have separate set of rules. Like taxation taxation exam, the Indian Odisha taxation services. But what happened in the all those minors? I'm referring to one rule minors. That is, rule 2, it is rule 2003 minors referred to, that 1991 to page 265. That is Odisha Civil Service Combined Competitive Recruitment Examination Rule 1991. What that did is, once that rule is there, minors, they have made specific provisions, how the selection process is to done, minors. A preliminary examination that has been prescribed. Procedure of written examination have been prescribed. Procedure of viva examination, courses, subject, courses, everything have been prescribed. This is relating to minor. This covers, so far, this covers 10 number of recruitments. Under 10 number of recruitment rules. It doesn't cover these engineering services. These engineering services is covered under 2011 rule. This is a rule 1991, which is prevailing and the process is going on. And that same practice is being followed throughout. Now, minors, what happened? This 2003 rule comes. 2003 rule has not specified all these recruitment process and all those. They say that must be a competitive examination, leaving minors a scope to the Public Service Commission to choose their own procedure. And they have procedure, maybe minors through recruitment, whatever they are in the recruitment process, they adopted it and they followed it and they have undertaken that recruitment process. This is my humble contention. I have given a written note of submission, minors. That may be accepted, and I have given some document referring to GATE, minors. The status of the GATE. I have given, minors, the website noting, minors, that is there in page 10.
Yes.
Page 10.
Any other submission?
Yes.
Page 10.
Yes, Mr. You are for?
Filed an intervention in various ultra-vires case, as well as the writ application, asserting the interim order passed by single judge.
In writ appeal.
Writ appeal. I'm sorry, my lord. Writ appeal. Everything has been discussed, so I will not waste your lord's valuable time. I will only make general submissions. My first submission is a statutory rule is presumed to be valid unless otherwise declared ultimatum by the competent court of law. Therefore, the interim order passed by the single judge is not sustainable. And ordinarily, in a case where statute is there and virus is challenged, no interim order should be passed. And here is a case, it is not passed. Therefore, statute still governs the field. We entirely adopt the argument of government as well as the PSC, because the relation is employer and employee relation and or master and servant relation. Though it is a state government, under to Article 14, 16, 311, 2B, everything, but it is domain of the government to make a statutory rule for any particular recruitment, and the intent to get the best one.
No, but you have limited scope of argument because you are.
Therefore, I won't precise. I'm not going to the any paper.
Yeah.
My lord. And merit is the paramount consideration.
Without going through the any paper, you can argue for hours.
Lord, I may be that as it may, my senior was first read me the constitution. My senior was former Advocate General. He was first taught me the constitution.
Yes.
And secondly, my lord, so therefore it is the government under Article 9 of the constitution empowers to frame any recruitment rule for purpose of different post and different post, my lord. And my lord, my another submission would be that it is now admittedly OPC has appeared and said we have been duly and or effectively consulted. Then, my lord, my humble submission is there are also scope of shortlisting.
Yeah.
Therefore, my limited submission is that statute is valid. Master has the domain to decide what would be the criteria of selection. And Rule 6 and 7, they are saying Rule 6 is eligibility. Rule 7 is criteria of selection. One may be eligible, but one may not be selected within the criteria of selection. Last one, my lord, my humble submission would be that the gate, so far the gate things are concerned, and a question was posed by your lordship. Why gate? My experience, and it is also it will be accepted by bar, only on the basis of marks secured in ISC, one could have been admitted in medical or in engineering. Thereafter, they introduced JEE, NEET, NET. Even for the ISCT teachers, they have introduced. I will file a God lot with all authorities. The proposition I have advanced, and thereby the writ appeals should be allowed, and the interim order should be vacated. They should declare the result. That's all, my lord.
May I please, my lord? My lord, I come last in the line, my lord. My lord, I am appearing for one of the interveners. In the second case, my lord, there is IA number 1919 of 2024, my lord. My lord, just to add on to the submissions of my learned seniors, my lord, I'll just address your lordship on very few specific points without taking much of your lordship's time. My lord, a reference to Rule 2003 was made by learned senior counsel, my lord, appearing for the petitioners in the midst of the hearing, my lord. My lord, if I'm not wrong, my lord, there is no pleading to that effect in the writ petition, my lord.
On?
My lord, so far as Rule 2003, reference to Rule 2003 is concerned, my lord, it was.
The pleading is not required. When you are challenging someone is challenging the virus, it is not required that everything should be pleaded.
But all that I'm trying to, Lordship, that the state should have filed an response to that, my lord. And they cannot be taken by surprise by raising a plea in the midst of a hearing, subject to your lordship's approval, my lord. But now Rule 2003, my lord, my learned seniors have read it time and again, my lord. The 2003 rules came before. 2012 rules, my lord, the recruitment for engineers, it came in 2012. My lord, now, prior to the amendment in 2015, the effect was in Rule 5 was always there, my lord. But I'll just read out the overriding effect, that's Rule 5. The provision of these rules shall have overriding effect, notwithstanding anything contrary contained in any other recruitment rules for the time being in force. But by that time, my lord, 2012 rules were not in existence. 2012 rules, my lord, it came in 2012, and it is a special rule for recruitment of engineers. So this is a general rule, and the special rules, my lord, would naturally override the provisions of this rule because that was not in existence at that point of time, my lord. Amendment which was carried out only in 2015 only confined it to Rule 3, 3A and 3B, my lord. There was, so far as Rule 5 is concerned, it was not touched, my lord. Now, score, my lord. But a gate score, my lord, as it has been argued, it is every year, my lord, the candidates, even who are in the third year, they are eligible to sit for the gate exams. And what was the purpose of introducing gate, my lord? It was a very noble idea on the part of the state government to have introduced gate, my lord, because the suggestion came from OPSC, my lord. That has not been brought before your lordship, but the suggestion came from OPSC that they found that people who had scored very high marks in their academics and all, at the time of interview, my lord, they were scoring, they were absolutely, the performance was far below, for which reason there should be some new way of recruitment, my lord. And thereafter, this gate system was adopted, my lord. And gate,
but there could be another reason also.
Yes, my lord.
The OPSC might be finding it very difficult to hold examinations. Therefore, why not rely on some other score?
No, my lord. Yes,
it's very convenient.
Yes, my lord.
If it is the function of the OPSC to hold examination, and the OPSC advises that what for we should hold the examination, let us have the score of GRE or GATE or something, and then all the selection processes, interview 10%, select, make all the of having this constitutional scheme.
No, my lord, also it failed from your lordship's mouth that it may so happen that the OPSC must have been influenced by the state government.
Everything. It is not that we are saying everything.
Yes, my lord. No. So therefore, my lord, to address your lordships on that point, my lord, I just rely on two judgments of the Honorable Apex Court, my lord. Your lordship is kindly.
On what?
Where the Honorable Apex Court way back in 1957, as well as in 1984, they've held that the word shall, which operates in Article 320 of the Constitution, my lord, it is not mandatory, but it is directive, my lord. So therefore, the position is very clear that the opinion of OPSC is not binding on the state.
Who says?
Yes, my lord. My lord, this is...
Why do you need any judgment?
Nobody disputes that.
Yes, my lord.
It says
Why judgment?
Yes, my lord. Then in that case, I'll just go. Now, my lord, as of now, my lord, the final publication list for electrical candidates has been published. So, my lord, none of the electrical candidate students are there before your lordship, my lord. Now, far more injustice would be done to them and also to the present batch of GATE students, my lord, who have already appeared and the provisional list has been published. They have started for the interview. Far more injustice would be done to us than to the petitioners, my lord. But at the petitioners, my lord, many of them, if they're asked to file an affidavit before your lordship, they were there before your lordship in 2023 in the earlier round. And my lord, many of them had opportunity to sit for gate, but all through they were sitting, and many of them, they have also sat for the exams, not passed, and therefore this writ petitions. So therefore, my lord, far more injustice would be done to the people who have already, the provisional list, have sat for the interview, and interview is completed, and also electrical students, my lord, the final list has been published. The final selection list has been published, but they should have been at least arrayed parties over here, but they're not before your lordship.
So you're saying the writ petitions have been filed after the final list was
No, my
published?
lord, before. But at least they should have added them, at least one of them. But now this, so far as the gate score is concerned, my lord, the validity of a gate scorecard is for 3 years. Therefore, the earlier recruitment rules prescribe valid gate score for the preceding 3 years, including the date of the advertisement. So why 3 years? Because the scorecard of the validity of a gate scorecard is 3 years. So now the candidates of 2021 are eligible, 2022 are eligible, 2023 are
Yes, we
eligible.
understand.
Yes, madam. But so far as 2024 are concerned, my lord, they are not eligible. And to accommodate 2024 or beyond that, my lord, the candidates who have scored gate scorecards for 2021, they'll be taken off, my lord. That's all.
Yes, anything else?
What reply can you?
Yes, yes. No, today you can complete tomorrow. Already tomorrow.
Tomorrow, I have some difficulties.
So do you have also to reply? Or you can discuss with him?
Then
He
I-
will reply on your behalf.
But let them submit tomorrow if your lordship kindly have to.
No, we are doing it on day-to-day basis.
Can it be there for tomorrow?
ନହେଲେ ମୁଁ ଆଜି
No, we are
କରିଦେଉଛି
better.
after lunch.
We are doing it on day-to-day basis. Tomorrow, tomorrow.
Then your lordship may allow me to conclude today.
Yes, yes.
Then I will sum up the arguments, my lord. On behalf of the petitioners, my lord, and my learned friend, he has to examine certain things to meet your lordship's queries. He can reply tomorrow. My lord, to sum up the submissions, my lord, well, I made a submission, my lord. I have brought the lordship's notice, Rule 6 and Rule 7. My first submission was that they are mutually destructive of each other as much as eligibility scope to all graduate engineers to be considered, whereas criteria of selection in Rule 6, 7 results in negativing those graduate engineers to be in the zone of consideration. And that is one conflict in between Rule 6 and Rule 7. Then the next submission was that since it is a matter of public employment, it is violative of Article 16 and doesn't give a equal opportunity to all candidates. The third submission was that it creates a class within class, and therefore candidates who had the eligibility criteria, they are all graduate engineers, including those who appear in the graduate engineers. But graduate engineers giving a 90% weightage on the basis of the gate mark, this forms a separate class, and therefore it is hit by Article 14. Then the fourth point was...
No, see, the argument which can be against you is that you have the qualification. All right. You have the qualification. If you want your participation or you want your recruitment in accordance with the rules, then you please appear in the gate. All right. You had to score you will be considered.
Well,
It is not that it amounts to your exclusion
that is
altogether. Rather, it is made compulsory that if you want to be considered, you apply there and have the score come for the process. That is the
my lord, earlier I told your lordship that there cannot be any proposition with the that the rule making authority has the right to prescribe eligibility, and a higher qualification and the eligibility. They have always the right, my lord. But my point is, probably I have failed to.
No, you are very clear.
Yes.
You say that two rules are mutually destructive for the reason that in the at the first place, they prescribe the minimum eligibility criteria, and in the second, they exclude you.
Yes.
All right. You stand excluded because you don't appear for the.
Had it not been for a public employment, I couldn't have argued this. Since
Right. So therefore, what they say that if that is the minimum qualification, education qualification, according to you, because of gate, you stand excluded, though you are qualified under Rule 6. This is your submission.
Yes.
If we have
Yes.
understood it correctly.
Yes.
What we are saying that your qualification is there. You are not excluded. You are excluded because you are not taking gate examination and you don't have score. Therefore, you stand excluded. We can understand these things in a different way. Like you have the qualification, all right. You have the basic qualification. Now the OPSC shall conduct a written test.
Yes.
All right. Now, if you say that, see, I am qualified, but we are being excluded because they are going to hold a test.
That situation would be different, my lord, in my humble submission, because there persons having gate qualification also are required to appear in the written examination. So also the general graduate engineers. So those who possess the minimum eligibility criteria are given a level playing field, my lord. Here, it is a question. Had it gate been a statutory, sir, well, the situation would have been something different. But since it is an optional exemption, while the appearing in a gate exemption is optional.
That was optional.
Well,
that was optional.
Now also it is optional.
No.
Because it is not.
Now it is not optional. If you want to qualify, if you want to compete, then it is compulsory.
If it is made
Rule 6. You mean
eligibility criteria or a qualification, my lord, then the 6 you remove. 6 you say that all persons appearing in the gate exemption, then criteria of selection highest score in the gate exemption. Section 7 criteria of selection. That is one thing. Then so far about opportunity is concerned, my lord, your lordship will kindly see that your lordship has probably, I didn't digress, as from the discussion it has fallen that 2021 we were given no advance notice, then came 2023. The other way it can be argued, that this 2021 notification having been struck down, how do you know that again this it will come up with a modification that 90%. That is why I told the discrimination can be by impact also. If the impact will not, you are bringing in the same thing, then it is also the discrimination. Then, Milord, about that time, Milord, I think Mr. Rautra has published that October was the...
No, even otherwise, because of the publication of result, you could not have taken advantage of that last year examination. What you are saying that time, that is not very important, because Even if you had applied and appeared, the results would not have been out by the time you appeared in the.
That's right. That is, my lord, Lord, the method of recruitment was published on 39/2023. This new notice. The last date was applying for gate exemption was 29/9/2000.
That this submission of yours is confined to your challenge to the advertisement, not to the rule.
Yes, but I am telling the summing of the
Right.
submissions.
We also wanted to be clear on this.
Yes, yes. This has nothing to do with virus. This is whether adequate opportunity is given to all. This is altogether different proposition because you are depriving graduate engineers without giving them a chance to even appear. This is like second leg. Assuming that gate is valid, then also the adequate opportunity ought to have been given. That point, I think your lordship has completely grasped it. I didn't digress the further. Then, my lord, about that judgment, that was placed before your lordships, that Idladhar and others, that they relied. No, what is that judgment, my lord? That judgment lays a stress that written examination should be given more marks. And in paragraph 4, 5, 6, thus the written examination assesses the man's intellect and the interview test the man's and the twin test. And they say that paragraph 8 says that it would be where the rules are silent, there you leave it to the interviewing board to fix up the percentage of the marks. And there it was 25% was for and it was upheld. So how it is against the proposition, rather the observation that in paragraph 5, 6 that it is time tested, that the direct written examination is much better way.
So they are saying that there is a direct written examination.
No, that is where, my lord, we differ. So what they are saying and we are saying it different. We say that had you prescribed the direct examination, then it would have been all right, my lord. But you cannot disturb, then the Rameswar Pandey case, my lord, one like this, that your judgment is relevant, my lord. That's going to be.
Can you address on just for a minute, Mr. Nathi? It will take hardly a moment. Can you distinguish between the test which is held, a written test normally, and the test which is held by GATE? So what is, how does it differ?
GATE, Lord,
they also assess the competence of a candidate to understand the respective subjects like mechanical, engineering, whatever.
So as to,
same thing is it.
So as to, not every institution has the right to choose persons to their own faculty on the basis of either in the basis of the marks obtained in the eligibility condition to be get admitted to a postgraduate classes or to conduct even certain they conduct exams. Well, these the gate score is in respect of certain institution. It is not in respect of all IITs. Some of the IITs, that is there, it's a gate of percentage.
No, that is different. That is the body. The body which conducts the examination, that is that body works in collaboration with various IITs and under the government. That is done by the Indian Institute of Science. That is one of the most reputed institutions of the country.
I am not there, no. I am telling that qualifying in GATE is a mandatory for seeking admission and or financial assistance to master and direct doctoral program in technology, architecture, and certain things. But this is
once it is decided, once a policy decision is taken by the government, that is a very good test, like standard test for testing the
eligibility criteria.
No, not eligibility criteria. For testing
Merit.
Merit
That
of
is
candidate in
why,
that subject.
Why I am again and again telling you lot that if you have prescribed the eligibility criteria and then take the scorecard, then it is all right. Probably that there cannot be any quarrel about it. But once you say that I do not pursue postgraduate for some reason or other, but I am in dire
So according to you, in Rule 6, they ought to have mentioned that the candidate must have appeared in GATE.
Graduate engineers and must have appeared in the GATE examination.
So to graduate engineers and to this qualification, had that been there, there would not have been any.
May not be having. Then that situation would have been something else. I don't know, one line I have cite from that decision of Bihar, at page, your Lordship will kindly see. Yes, sir. It is thus the submission of Mr. Singh that it is by virtue of such illegality by the state in its science and technology that though the petitions are eligible for the eligibility of table 1 of appendix 1 to the rules of anesthesia, but they are deprived of the appointment so notified through the advertisement in question because they have not possessed the gate.
So there, whether in the rules, GATE score was mentioned.
Eligibility, table 1 prescribes the eligibility. Eligibility prescribes that postgraduate in the respective faculty.
No, that is not the question. The question is whether in that case, the rules prescribed that GATE scores have to count for preparing the
interview.
In that case, it was there in the advertisement, not in the rules.
No.
Have you, so someone has examined this? Please examine tomorrow. We'll continue.
Weighted scheme was provided in table 2 of the rules. Table 1 prescribes the eligibility criteria. Weighted scheme was in table 2.
The appellant is a bank, madam.
Appellant is a?
Is a bank.
And appellant has challenged this, filed this appeal challenging this judgment dated
Where?
17/10/2022, passed in WPC number 24149 of 2020 under Annexure 7. My lord, kindly have a glance to the impugned judgment. That is Annexure 7.
Who is on the other side? Your opinion.
Myself and Mr. Raghav.
We are both, my senior and I.
Yes, what is the point involved?
My lord, kindly have a come to the paragraph 9, the operative portion of the impugned judgment, so that the point can be, your lordship can derive the point. What is the point set involved?
Which page?
At page 72 of my appeal memo.
Yes.
This is a case where petitioner will approach the bank. May I read my
Paragraph 9.
paragraph 9?
Yes.
That is the operative portion.
Yes.
This is a fit case where petitioner will approach the bank for issuance of duplicate FD received in terms of the rules. The bank is directed to make available indemnity bond format and other requisites and formalities to be complied in regard thereto. So far as bank's contention of dispute raised regarding competence or authority of the person representing the trust is concerned, court has ascertained that following judgment dated 18th November 2014 supra, the collector handed over the charge of the trust to the same person who has petitioned court on behalf of the trust. In these circumstances, there should be no delay on part of the bank to enable petitioner to apply for and obtain duplicate FD receipt. On obtaining it, petitioner will act in its best interest. Now, the question here, the ground of appeal is when the original fixed deposit receipt is very much available in the registered office of the trust, can the bank compel to give duplicate FD receipt? And that too, the person to whose competency is
where?
in the registered office of the trust. The money belongs to a trust.
Yes.
And the original receipt is very much available in the trust office.
Yes.
And the petitioner who has applied for withdrawal of that money, the bank has questioned his competency to represent the trust. Because when the money was deposited, he was not the authorized signatory. Subsequently, he came forward to the bank and applied that I am the chairman. The bank has asked him that you produced all the documents.
Respondent here.
My lord?
The petitioner is respondent here.
Respondent number 1. The petitioner is the respondent number 1 here.
Who is he? What is his name?
Bansidhar Pradhan. He has filed that writ application, identified himself as chairman.
Chairman of the trust.
Chairman of the trust.
Which trust? Which trust?
It is Climate Trust. I'm coming to the Kalinga Institute of Mining, Engineering and Technology Trust. Climate Trust, it is.
Mining, engineering and
Technology Trust.
yes.
So the money belonged to the trust. When the money was deposited in the bank, he was not the authorized signatory. Subsequently, the person came forward, identifying, declaring himself as the chairman of the trust and demanded the money. The bank asked him that you produce all the documents because it is in compliance with the circulars issued by the RBI. My lord, may kindly have come to page.
No, then what happened?
The bank, he produced certain documents which are found to be forced. And
who produced documents?
That the respondent number 1.
Then?
He produced a resolution claiming that by virtue of this resolution, I was been appointed as the chairman, but the signatures were found to be forced. Now the person who has attested that document is a stranger to the trust. I'll come forward. I'm coming to the point, my lord. Why the KYC is necessary? Because, my lord, I filed the master circular of the Reserve Bank. That is under Annexure 6 to the memorandum.
This writ petition was filed by whom?
By that person. The person self-declared chairman. The person who himself declared as chairman and filed the writ petition. I have challenged this competence.
So whether this Kalinga Institute is a party in the present proceeding? Kalinga Institute of Mining is a party.
No, only the person who has filed
See, therefore, the person who filed the writ petition,
Is a party before the, is,
Kalinga, the writ petition was filed by this Bansidhar Pradhan.
writ petition was filed.
Just a minute.
Yes.
Let me complete the sentence. Writ petition was filed by Bansidhar Pradhan, claiming to be the chairman of Kalinga Institute of Mining.
The writ petition was, I may be pardon, my lord.
All right. The writ petition was filed by Kalinga Institute of Mining Technology.
Represented by Bansidhar.
Just a minute. Through the Bansidhar Pradhan,
Yes.
claiming to be the chairman,
Chairman.
which he was not according to you.
Yes, my lord.
Which he was not according to you.
Yes, my lord.
Our question is whether Kalinga Institute was a party in that proceeding.
No,
No.
no other.
So according to you, he is not the chairman, and there are two entities. One chairman of the one who had filed, and Kalinga Institute. In fact,
Yes, my lord.
are we clear? The writ petition was in fact not filed by the Kalinga Institute.
Yes,
It
my
was
lord. It
Not
is filed by someone else claiming to be chair.
claiming to be the chairman.
Yes.
And therefore, whether Kalinga Institute is a necessary party for just adjudication of the present dispute or not is a question.
It is a necessary party.
So whether you have impleaded,
No, the writ petitioner is not impleaded. I am in appeal, my lord.
at this stage, is it required that this institute appears to respond to the stand which was taken in the writ proceeding by the
Because, my lord, the question is the competency of Bansidhar Pradhan. I think may not require your lordship, subject to your lordship satisfaction. The competency of that Bansidhar Pradhan is under challenge. It was questioned by the one who, but the honorable single judge has accepted. No, he is competent in view of this.
After all, the fixed deposit was in the name of Kalinga Institute. So the amount will go in the account of Kalinga Institute. Not in favor of this Bansidhar Pradhan.
Yes, ma'am.
So even if he takes the amount for being credited in the account of this Kalinga Institute, then there is no issue.
No, my lord, he has applied to transfer to issue the demand draft, which will be deposited by which account. He has not disclosed in which account it will. He filed an application before the bank that issue the demand draft. That I will show you, your lordship, I will show you. In favor of that Bansidhar Pradhan.
Achha.
He is operating, and the fact remains that there is a dispute. The judgment which
All right. Is it an admitted fact that original FD receipt is available?
Yes, ma'am.
This is an admitted fact.
I have filed an affidavit before the honorable single judge.
With whom?
With the custodian in the registered office and the person who is known as Sukanta Mahanti.
Who?
Is the principal in charge, the in-charge principal of that, who is in charge of those documents. I filed the specific affidavit.
Is it someone's case that the FD receipt has been lost?
It is the Bansidhar initially said that I have received, I have not received. The collector has not handed over. Then the direction was issued to the collector Onugul to file an affidavit. He filed an affidavit that yes, we have. I also filed an affidavit that the annexure 2 of his own writ petition clearly shows that he has received that FD receipt. Then he changed his stand. Then he said it is lost somewhere else. Then when he changed the stand, it lost somewhere else. An advertisement was issued in a newspaper which doesn't have any wide circulation. Now thereafter I filed an affidavit. No, it is available with your. Because continuously he is changing the plea in the writ petition and the subsequent affidavit.
Please take your seat. Let me hear them. Let us hear them. Yes. Yes, Mr.
Yes.
Why you?
Your lordship look to is totally, I can with all respect to her, misinterpretation of facts. But this matter has been already resolved by this honorable court in the second civil suit, where the second appeal, where a receiver collector was appointed as receiver, and the second appeal it was that Banshidhar Pradhan, respondent number 4, is the managing trustee, and the collector was directed to hand over all whatever possession to the managing trustee Banshidhar Pradhan, and collector in fact handed over everything. And after handing over, so far as this receipt is concerned, the Honorable Single Judge directed the collector to file an affidavit. Collector also, after inquiry, filed an affidavit that it had not been handed over. Then this judgment was passed. First of all, I'll take your lordship to the judgment of the second appeal so far as the locus standi of the chairman is concerned. It has been quoted by the Honorable Single Judge, but I'm giving to your lordship the judgment. So look to the last operative person. So far as the locus standi of the respondent present, that has been annexed as annexure 1 to the REIT application. But because the REIT application is 1, therefore I am giving a copy to both of your lordships. Your lordship kindly come to page.
No, but Mr. The direction is for issuance of a duplicate certificate. Duplicate receipt.
Because that receipt is not available. That was the affidavit filed by the collector pursuant to the order passed by the Honorable Single Judge. That is not available. Therefore, the Honorable Single Judge has directed in terms of the RBI guideline that you have to publish in a newspaper, then you have to indemnity bond. That has been already complied with. We have already given in terms of that. Also, just have a glance. Also, look to the so far as the present, the REIT petitioner. Now, REIT petitioner is Kimet represented through the trust, through the managing trustee Banshidhar Pradhan. You also looked at what is the locus standi which has been upheld by the Supreme Court. That is the judgment at paragraph 20. Just to also kindly see. That is
reading what?
Paragraph 20 of the judgment of this honorable court. I am giving to lordship. This is
Second appeal.
a second appeal. Also look to that. This has been also annexed to the REIT application.
Annexure 1.
Annexure 1 to the REIT application.
To the writ petition.
Yes. Because REIT application is a single judge.
Yes.
Therefore, I have given a copy of the judgment to your lordship's second appeal judgment. And this has been quoted also by the Honorable Single Judge in the impugned judgment. In the result, let's get it.
Which paragraph?
Para 20, internal page 19.
Yes.
In the result, the second appeal is dismissed. Another person claiming to be the trustee has filed it on contest, but in the fact and circumstances without cause, judgment of the Law and Order Appellate Court is confirmed. Respond number 4 and 5. I am respond number 4. Respond number 4 is the Banshidhar Pradhan. And respond number 5 being found to have never ceased to be the member of the trust board are entitled to act as the board of trustees under the deed of trust as well as the bylaws of the trust, including the management and functioning of the trust, that is the institution, the schemates, institutions. Appellant number 1. The receivership shall stand terminated because collector was appointed as receiver during the pendency of the suit. The receivership shall stand terminated on the expiry of 2 months from the date of this judgment. The collector on good as receiver shall hand over the charge of the entire management of the institution to the members of the trust existing as on the date of handing over such charge. On the expiry of the aforesaid period of 2 months, the receiver shall cease to exercise any function in respect of the institution, including exercise of financial power. The receiver shall submit account for the entire period of the receivership before this court within 3 months from the date of the judgment, and after acceptance of the account, the receiver shall stand discharged. Then you also kindly come to the impugned judgment. Impugned judgment, the Honorable Single, this has been upheld by the Supreme Court, that has been also noted by the Honorable Single Judge. You also come to page 68, running page 68 of the brief in the appeal. Para 2. Against the aforesaid judgment, also get it?
Please.
Yes. Judgment, that was a special petition made to the Supreme Court on 6th January 2015. It was dismissed. He demonstrated that the administration relinquished control over the institution to his client. That is, to his client means Banshidhar Pradhan. Then suddenly by memo dated 13th May 2019, the administration wrote to several banks as follows. With reference to the subject cited above, you are hereby directed not to do any kind of financial transaction in favor of the Institute of Kimet, Chedipada, without prior clearance of the collector on good. Appropriate officer of Kimet, Chedipada. This is for your information. His client was compelled to approach this court by WPC number swans of 2019, disposed of by order dated 28 September 2020, pursuant to which Commissioner cum Secretary to Government directed the administration to withdraw the memo. It was withdrawn by subsequent memo dated 23 November 2020. In spite of the memo impeding banking transaction having been withdrawn, his client was again compelled to approach this court in WPC number 11646 of 2019. A coordinate bench said that nothing remained to be decided in the writ application and made following observation, quotation. So far as the fixed deposit of the trust estimate is concerned, the petitioner may apply for approval from fixed deposit before the concerned bank, and the manager shall take a decision on the application in accordance with the rules of the bank within a month of filing of that application. Today he submits petitioner is before the court against inter alia letter dated 8 July 2021 issued by OP number 4. OP number 4 is the bank, whereby petitioner has yet again been obstructed from encashing the fixed deposit standing in its favor. It draws attention to order dated 8 December 2021 and submit as a constituent hearing that came to be made order dated 21 September 2022 directing the collector to file an affidavit, evidence regarding whether or not the office had handed over the fixed deposit receipt. Mr. Sharma, an advocate, additional government advocate, appear on behalf of the state and submit affidavit dated 12th October 2022 has been filed. The collector has said that no FD receipt was available. But at the time of handing over charge, no FD receipt was available. In support, copy of the document dated 15 January 2015 has been annexed, giving particulars of document giving on handing over charge of entire management of the institution to members of the trust. That means to me, as a managing trustee. 6. Mr. Roth, an advocate appearing on the behalf of the bank, he submits competency of person to represent petitioner is disputed by his client. The relation of persons representing the trust is to be determined by prior to which the client cannot disperse the proceed in a fixed deposit account. He submits that further, his client found original FD receipt in the office of the trust. On query from the court, Mr. Rotha is unable to give date of discovery of the original in office of the trust from which photocopy was made and handed over to court. Mr. Rautra refers to the impugned letter dated 8 July 2021 by which the bank has refused to disperse the proceeds in the FD accounts. Following from the impugned letter is extracted and reproduced below. From the document submitted by it is clear that you are never validly appointed as the chairman of Kimet Trust as on 15/1/2015 and subsequent thereafter. There is no declaration by competent authority or by any competent court of law declaring you as the chairman of the Kimet Trust, enabling you to operate or withdraw the amount kept in fixed deposit amount number so-and-so. Fixed deposit FD account number so-and-so was opened jointly by the collector Angul while the receiver. Collector Angul as receiver of Kimet Trust and Tahsildar with an amount of 2 crore. As on 5/7/2021, the maturity value of amount comes to this 3 crore amount. In absence of a declaration by competent authority or by a competent court of law having jurisdiction, it may not be permissible under the banking rule. This was their order to disperse amount to you on behalf of Kimet Trust. This may please be appreciated and do the needful, enabling the undersigned to release the amount in favor of Kimet Trust through a competent representative and oblige. It is clear from the bank's position taken by the impugned letter dated 8 July 2021 that the fixed deposit was created by the collector. Original receipt therefore should have been in the office of the collector. The affidavit filed omits to say the original FD receipt was made over at the time of handing over charge. The bank has also not been able to disclose when the original FD receipt was found to be in the office of the trust. This is a fit case where the petitioner will approach the bank for issuance of duplicate in terms of the rules. The bank is directed to make available indemnity bond format and other requisites on formalities to be complied with in regard thereto. So far as bank contention of disputes raised regarding competency or authority of the person representing trust is concerned, court has ascertained the following judgment dated 18th November 2014 Supra. The collector handed over the charge of the trust to the same person who has petitions court on behalf of the trust In the circumstances, there should be no delay on the part of the bank to enable the petitioner to apply for and obtain duplicate FD receipt. On obtaining it, petitioner will act in the best interest. So far, the intervention others also that has been rejected.
So you can receive that, but you will have to deposit that in.
Yes, sir.
the
Yes,
account of
yes,
the trust.
yes. There is no dispute over that. That will be deposited in the trust account. That means that's a KIMET account. And petitioner has been held to be competent by the civil court, which has been upheld by the Supreme Court. And in terms of that, collector has handed over the charge to the respondent number 1. And he is the other trustee is this person. And that is a resolution already for the interest of the institution, nothing else. And how the bank has come forward to say, and some public has come forward to file an application for intervention, and they
Application to no other person.
Sir,
I the retail mailer, which is connected here today, that is by the public. What has happened? There was a lot of misappropriations by this Bansidhar Pradhan, so far as the trust property is concerned. So the villagers have filed a suit under section 92 of the Civil Procedure Code to questioning the misdeeds of the trustees. Then that suit was, upon inquiry, admitted. After the suit was admitted, the Bansidhar Pradhan has filed a civil revision against that order, and in the civil revision, that operation of that judgment was stayed. Thereafter, the entire proceedings are going on. Somehow they are interested to just take away the money which is available in the account. So bank has said, so it cannot be given to you unless the real trustee. So in the writ application, when the KIMET represented by Bansidhar Pradhan filed impugn writ petition, I have filed an intervention application narrating these facts and saying that the villagers have already moved the civil court, and the civil court, after inquiry, has admitted the suit under section 92 of the CPC, and that has been subsequently stayed, and civil revision was also dismissed later. But my application will also kindly see only one paragraph of the impugned judgment.
See, it appears that the bank and you also question the locus standi of Bansidhar Pradhan.
Yes.
All right.
Yes.
On the ground that he is not connected with this trust KIMET or whatever.
On the ground that he is misappropriating that money.
No. Maybe.
Right. Not totally connected.
We may be incorrect, but let us complete. The dispute before this court has been decided in the absence of, there must be a board of trustee.
Yes, sir.
There must be some
board of trustee consisting of himself only.
Huh?
Consisting of himself, his driver, like that.
Don't say those things, Mr.
But that is there on record. In the suit, it is there. I am not saying something new.
That can be. So what is KIMET Trust?
KIMET Trust. KIMET Trust was a party to that suit. KIMET Trust representing that institution.
KIMET Trust was party to the
education
writ proceeding or not?
Yes. KIMET Trust had come up. Trust had is a petitioner. Trust is the petitioner. Before in the writ application.
Represented by him.
We are saying
in the correct picture.
that we are seeing that that trust is
represented managing trustee.
One of the trustees.
He's a managing trustee. He has been held to be the competent because of the.
No. He has been held to be one of the trust. Two of them have been held to be the trustees.
Yes.
All right.
Right.
And on that ground, how many trustees are there?
Now
two trustees.
I have
one is
been
dead.
added as a party. I'm the opposite party number 8 in the writ application.
Where?
Manoj, your lordship, may kindly see the impugned order?
Impugned order, there are only 4 parties.
Your lordship, may kindly see.
Order dated, writ petition
other-
2414.
Only 4 parties.
Only 4 parties.
I had filed an intervention, and I had my intervention in that I had also filed an independent writ matter.
Yes,
against which the private opposite parties have questioned that.
Another thing, the second appeal, you've been declared as one of the trustees, but you filed this writ petition as chairman. There's some supporting document for that.
Subsequently, he was authorized by the trustees to take over the charge from the collector. And if you also look to that, that is also enclosed to the writ application. That this is the That,
Nay.
that
He authorized himself or what?
No,
No,
what is the
Yes.
constitution of that board?
Constitution. In fact, the person who was originally another member, Mr. Gobind
Chandra Naik.
Naik, he died after the death, and he has been taken substituted in place of that Gobind Chandra Naik.
After death of the another trustee, my lord, two trustees were held to be valid trustees.
Valid trust.
One is Bansidhar Pradhan and one is Gobind Chandra Naik. When the collector asked Gobind Chandra Naik to come and take over charge, he did not take over charge. Only Bansidhar Pradhan was given the charge. Subsequently, Gobind Chandra Naik died. After his death, it cannot function with a single member. There was in which I was taken as the trustee, and the new trust was formed. And I was also I had filed an intervention in the writ application and also an independent writ. So both the writ petitions were disposed of by the Honorable Single Judge, holding that the trust is to take the money by providing indemnity bond, which your lordship has said. So now there is no dispute that the trust is not in existence.
You also look to this is pursuant to the judgment in the second appeal, Supreme Court. The collector's decision is this.
That is page 41 of the writ application.
This is also page 41, yes. Handing of this office of the collector, district magistrate, handing over charges of the entire management of the institution Kimet to the members of the trust board Kimet in pursuance of the order dated 18/11/2014 of the Honorable High Court. We have this day on 15/1/2015 in the afternoon made over and taken over, assumed charge of the entire management of the institution of Kalinga Institute of Mining.
All right. Show us any document whereby you have been elected or as the trust chairman of Kibet.
Yes.
Where is that?
That is, I think nobody has disputed.
That is annexed to D/4 at running page 80.
Just a minute. So where is that?
But
You are the chairman.
Because that was never a question.
That is the question.
The counter affidavit filed OP number 4 in the WPC, if your lordship will look to annexure D/4 at page 14. That is available in the writ application itself.
Yes, counter affidavit.
D/4. Counter affidavit filed by OP number 4. Meeting of the Kimet Trust. It is Dawasara.
Counter by D/4 is not there. D/3 is there.
D/4, that is affidavit dated.
Respondent 1 is
The affidavit dated 6/9/2021. Counter affidavit on behalf of the OP number 4. Subsequently, you this was the resolution while Gobind Chandra, the other one who died. D/4 at page 14.
We will have to understand the trust law again, because this is on a letterhead of Kalinga Institute of Mining Technology.
Yes.
And then read the contents, and then resolution by Bansidhar Pradhan and Govind Chandra.
Yes.
He becomes chairman. So where is the here also he is the chairman Kimet.
Yes.
There is any document to demonstrate
That you are declared as the chairman. Yes. That document I'll show you.
Sure.
I'll show you. That is there.
List this matter on 1 week for senior land counsel representing the respondent number 1.
Respondent number 1. I'm happy to respond number 1.
Respondent number 1. And 2, to demonstrate that Bansidhar was ever elected as chairman of Kalinga Institute of Mining and Engineering Technology, bracketed Kimet, Chendi Pada Angul. So stop. For this court to appreciate the controversy arising out of the judgment of a single judge, which is under challenge in the present intra-court appeal, in the background of the grounds which have been taken by the applicant. Yes, so if he is found to be the chairman, then you don't have any problem.
No, he is not. He subsequently said, that is why I am
Alright,
that I have inducted someone.
Let
I don't have any, who is he, what is his status, there is no problem. But the question is, he inducted under the 1882 Act, section 1 of that particular act says that this act will not apply to any public trust. And the trust is a public trust, so therefore your induction is illegal. That is why I have rejected.
Not a public trust, sir.
Yes, it is a public trust. That my lord will decide
As
whether
an
it is a private
interpreter,
trust.
we have given the documents. We have given the documents to show that how the
Who are they?
gift-
They are the
gifts were
villagers.
given to the
How-
trust
what-
and how the
what-
trust was created.
How are you involved?
How are you?
Because this is the public money through which they have started the trust. And public money is being appropriated by one person. That is the grievance. Therefore, suit is there.
Public money appropriated by one person.
One person.
It should have been misappropriated by everyone.
Now they want to jump into misappropriation. They did not contribute a single rupee. Now the
I have given documents, all the gift deeds and everything.
As your worship knows,
the retired person now comes up that we will also have a pie of that cake.
All right.
Who are you? What is your
But
qualification?
I'm the second trustee.
What is your qualification?
Article 4.
Just a minute. What is your qualification?
My lord, that I produced, my lord. What is my, I have not, my lord, from a client, why should I ask his qualification? He has come as a client, I will deal him as a lawyer.
but my client, I think, is a diploma engineer.
Diploma. My lord, we fix it at 2 p.m. Anytime, as per your lordship permit, 2 p.m.
So in the first half, you are not available in the High Court.
No. Always. My lord had fixed to 2
All
p.m.
right.
That's why I was.
Item 37.
Mr. Bose, or who has given this? Please take it.
Well, let that be in the record. No?
Okay.
Let that be in the record so that next time we can address your lordship.
The second appeal also will give.
Yes,
It is already there in the record.
Item 37.
I beg pardon, my lords, on behalf of Mr. Panda in item.
Sorry,
37.
madam. Extremely sorry. This matter, we have not been in a position to decide. It involves what we issue.
This is a batch of case, my lords, and I am appearing in one of the case for the petitioner. My case is criminal revision number 555 of 2022, which is the fifth matter from the bottom. And I
My lords.
prepared a convenience compilation for my lords.
I may be pardoned, my lords. My lords, here in this matter, the entire batch cases, Mr. Panda has been appointed as amicus, my lords. We have inadvertently missed the matter, my lords. I pray if it can be taken up day after tomorrow, my lords.
We will
Yes,
pick with
pray.
someone else because see how many cases are pending because of this. So if required, we will take his, we'll request him again. Let us understand. Let us understand and we will appoint you as amicus. We will replace you in his place. All right.
I'm sure you must have read it. Otherwise, read it now while you sit, while Mr.
Yes.
addresses, you read.
Yes. Why are you leaving? Sit here.
The issue, my lords, the core issue, my lords, in this batch of case, my lords, pertains to the release of a vehicle which has been seized for an alleged offense, for the alleged commission of offense, my lords, under the NDPS Act, my lords. Now, if your lordship sees my compilation that I have given, my lords, in my case, my lords, the basic facts of my case, my lords, that on 13/5/2021, my truck, my lords, the vehicle in question, my lords, was seized and an FIR was registered, my lords, against two persons, against the driver of my vehicle and another occupant, my lords. I was not there at the spot. I am a man from Rajasthan, my lords. Now,
So whether confiscation proceeding has been initiated?
no, my lords. Confiscation has not been initiated, and in the meantime, charge sheet has also been submitted, and I have not been named as an accused person in the charge sheet. And under these circumstances, my lords, I filed an application under section 457
Yes.
of the CRPC, my lords, for release of my vehicle. Now, the impugned order, my lords, of the learned STJM, my lords, is at, my lords, annexure 1 to my criminal revision, my lords, at page 10. Now, it has been rejected, my lords, primarily on two grounds, my lords. The two grounds, my lords, the learned court below, my lords, has relied upon two judgments of this honorable court, my lords. One, my lords, of the division bench of this honorable court, my lords, which has now been reported in 2022 1 OLR page 900, and my lords, following that, my lords, by a learned single judge of this honorable court, my lords, in 3 criminal revisions, and the learned come to conclude that, my lords, the petition for release, my lords, once a vehicle is, my lords, seized under the NDPS Act, my lords, for an offense under the NDPS Act, the petition for release can only be filed by the investigating officer or the prosecuting agency. This is one of the ground. Second, my lords, the learned court below says, my lords, that under 457, vis-a-vis an offense, my lords, under the NDPS Act, my lords, the court is not competent or lacks jurisdiction under 457 to release the vehicle. These are primarily the two grounds on which my petition has been rejected. Now, if your lordship sees, my lords, so, my lords, the basic
457, let us see.
My lords, my 457, my lords, is at page number 54 of the brief. The page 55, the petition starts. Says, my lords, that that is his only source of livelihood, and in the meantime, since charge sheet has been submitted and he has not been charge sheeted.
Which part of section 457 prohibits the court from
CRPC.
directing release of the vehicle?
Yes.
Well,
yes.
My lords, 457 clause 1, my lords. Whenever the seizure of property by any officer is reported to a magistrate under the provisions of this code and such property is not produced before a criminal court during an inquiry or trial, the magistrate may make such order as he thinks fit respecting the disposal of such property or the delivery of such property to the person entitled to the possession thereof, or if such person cannot be ascertained, respecting the custody and production of such property. 2 is, my lords, if the person so entitled is known, the magistrate may order the property to be delivered to him on such conditions, if any, as the magistrate thinks fit, and if such person is unknown, the magistrate shall in such case issue a proclamation specifying the articles of which such property consists and requiring any person who may have a claim thereto to appear before him and establish his claim within 6 months from the date of such proclamation. So, my lords, 457 clause 1, my lords, gives the power to the magistrate, my lords, to give possession of the property, my lords. And this has been, my lords, this provision has...
Why the release was declined? Referring to 447.
457. My lord, I'll read out the relevant portion of the impugned order. Page 13. Page 13 of my matter, my lords. My lord has it, my lords, page 30.
Where is the order of reference?
My order of reference, my lords, is in the first brief. That is, my lords, the lead matter, my lords, criminal, not in my lords, criminal revision 503 of 2022.
Oh, where is that? Where is the question? Where are the questions?
Your Lordship may kindly look at order dated 8/9/2023.
In which case?
Your Lordship, lead case, your Lordship, that is criminal revision 503 of 2022.
No, 8/9 is the subsequent order. Before that, matter had been referred to the division bench by Honorable Justice S.K. Sahu.
8/9, 8/9.
23, your Lordship. There only, your Lordship, this
That is
honorable.
the subsequent order. Before that, Justice Sahu found that did not agree, so had referred it to a division bench.
Yes.
Thereafter, by order of the Honorable Acting Chief Justice, it was posted before Justice.
Mr. He said that, yes, no.
So he has also directed that.
Should we place with Honorable Chief Justice?
No, but
No,
where is
division
that
bench.
order? Which order?
Just.
Order?
That
Which
order.
order in 503? Where is the order?
Yes. No specific
No,
order.
that is another case.
Specific order.
Maybe in some other case, 9/11/2022 reference is made.
Wait.
Three 346.
Then 400. You got it.
Even 347. 22.
Is it because of the decision of the apex court in the case of Union of India versus Mohanlal that this?
Matters. The division bench followed their judgment. How to effectively implement that judgment in our state, that the division bench judgment of our Honorable High Court, my lords, relates to that. Following the division bench judgment, the learned single judge passed an order, my lords, stating therein, my lords, that henceforth the application for release has to be filed by the prosecuting agency.
Before the
So
magistrate.
that, before the magistrate. And
But here,
based on that, now the magistrate has rejected, my lords. But my respectful submission, my lords, based on some latest judgment, my lords, that can be filed by the owner. In fact, your lordships has also rendered a judgment.
without seeing this, it is not that we can't make mistakes also. We can also correct our mistakes if we
No,
realize.
I'm giving a Supreme Court order, my lords, I'll give.
After Mohanlal or before Mohanlal?
After Mohanlal, 2022.
So that single judge has said that whether there is a bar for, in spite of section 52A of the NDPS Act, whether there is a bar for consideration of applications under section 457. That is the question. So you are saying that it can be considered
It
under
can be
section
considered
457.
by the, my lords, my submission, my lords, it can be considered by the special court. Not by, because 52A of the NDPS Act,
Gives
your
jurisdiction
lordship,
to the-
those provisions, because that particular provision has to be implemented by the magistrate, as held in Mohanlal, followed by this honorable court. But so far as release of vehicle is concerned, my lords, those petitions can be entertained, my lords, by the special court, my lords, which
Interim
tries the offence, in fact.
The application not filed before the special judge. Why was the application filed before the magistrate?
So, that's was filed before the magistrate, my lords, but it could be, my lords, that reason, my lords, I cannot say, but my lords, it could be because of the decision, the division bench decision of this honorable court, my lords, wherein a number of directions, my lords, were given. So far as the effective implementation of 52A of the NDPS Act is concerned, my lords. And those petitions, my lords, were pending. In some of the cases, those petitions were filed prior to the case, my lord, prior to the judgment of this honorable court.
Yes.
Because there was a direction by the honorable division bench, my lords, that henceforth the district judges, my lords, will appoint the magistrates to deal with, my lords, the provisions under the section 52A. That is a direction, my lords, which your lordships will find in my convenience compilation, my lords.
Yes.
My lord.
So the only question is that whether the view taken by the learned single judge earlier that because of section 52A of the NDPS Act, section 457 of the CRPC shall have no application, because section 52A of the NDPS Act itself provides a procedure for disposal of the properties seized.
Right.
So this is the learned single judge has differed with the view hereby and he has referred the matter to the judge. That's the only question. That are just so not a very complex thing. Seven refers to magistrate. Means magistrate under the NDPS Act. That is the special court, not any other magistrate.
My lord, sir, for the purposes of 52A, this honorable court has interpreted in the division bench judgment, the magistrate does not mean, my lord, the special court. It is the magistrate, the JMFC or the SDJM.
No, where is that?
Yes, my lords. That point was raised, in fact, my lords. In fact, this is, my lords, at page 52 of my convenience compilation. One of the points that was raised, my lords. Page 52 of my convenience compilation. This is judgment reported in 2022 1 OLR, page 900.
Page 20.
My lords, and at page number 52 of my convenience compilation that I just.
That Ashish Mahanti, that case or not that?
No, my lord. This is, my lord, State of Odisha versus
Yes.
Registrar General Odisha High Court.
Both were decided during the same time,
Yes.
right?
So,
In fact, in accordance with this, every time the state periodical updates you
Yes,
give
upgrade
regarding
some right
disposal.
laws.
But this,
There is a general direction.
but this probably relates to drugs
Not
and
so,
substances, not the conveyances.
not convinced right now.
Another thing is this is regarding disposal,
Disposal. 52 is
and 457 is regarding interim release.
interim release of lots.
And 52A refers to disposal of seized narcotic drugs and psychotropic substances.
And conveyances lots.
that if I may.
And another thing, if has the state government come up with a notification regarding the officer who has to deal with disposal?
Yes, yes. After the
Does it-
insertion of 50.
Does it mention conveyances, that notification? Because 52A says they have to come up specifically with a notification to deal with this. So in that, is it mentioned conveyances also, only narcotic drugs?
So, offhand, my lord, I do not have that notification
but
with me,
just-
but
just
the
check that
question that
also.
my lord posed, that magistrate, that
Yes, look at Standing Order 1 of 1989. Is conveyances mentioned there? think that came up for consideration in Mohanlal, that standing order.
In Mohanlal, the court never dealt with conveyances. The court was only dealing with NDPS.
Another thing, that standing order of 1989, does it mention conveyances? I don't.
It does.
Does?
I'm sorry, I have missed the list. So I didn't know that the matter will be taken up. But your lordship may see section 51 of the NDPS.
Yes.
Lord, section 51 says
But
that the provisions of the Code of Criminal Procedure 73 is to apply to warrants, arrests, searches, and seizures. The provisions of the Code of Criminal Procedure 73 shall apply insofar as they are not inconsistent with the provisions of this Act to all warrants issued and arrests, searches, and seizures made under the Act.
I can see. There.
Yes.
Then your lordship may see
Before coming to that, we'll consider that later, just for the purpose of removing my own doubts. Please come to subsection 3 of section 52, capital A.
Yes. 52A, subsection reads, where an application is made under subsection 2, the magistrate shall, as soon as...
Magistrate means what?
My lord, subsection 2, I am placing subsection 2 so that it will be clear. It says, 52A subsection 2 says, where any narcotic drugs, psychotropic substances, controlled substances, or conveyances has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53. The officer referred to in subsection 1 shall prepare an inventory of such narcotic drugs, psychotropic substances, controlled substances, or conveyances containing such details relating to their description, quality, quantity, mode of packing, marks, numbers, or such other identifying particulars of the narcotic drugs, psychotropic substances, controlled substances, or conveyances, or the packing in which they are packed, country of origin, and other particulars, as the officer referred to in subsection 1 may consider relevant to the identity of the narcotic drugs, psychotropic substances, controlled substances, or conveyances in this Act, and make an application to any magistrate for the purposes which are outlined, A, to certify the correctness of the inventory so prepared, or B, taking in the presence of such magistrate photographs of
So
such
this
drugs.
is for any magistrate, not the special judge.
No, it's for any magistrate.
This is for any magistrate.
And then subclause 4 says that this inventory will be treated as the list of as primary evidence. So that
if an application is to be made for release of the bill or anything, then that will have to be made before the special judge who has the
it
power.
has to be made
For
before
the
the special
magistrate.
judge. Yes.
Magistrate has a limited role only for the purpose of seizure,
That inventory and all that.
certification of seizure, preparation of inventory, that's all.
Yes.
Otherwise, all the powers are vested with the
Special.
court. Now, the main question remains whether Section 52A provides a detailed procedure for disposal, and therefore the magistrate under 457, and here the magistrate would mean the special judge. So he has the power to direct release of the vehicle or not. This is the question.
Exactly.
What is your submission? What is your...
He has the power and he is to deal with it in view of section 30, section 51. He has to consider it, and he is not
debarred from consideration.
Section 30.
My lords. I'm sorry, section 36. C, your lordship, not section 30, 36C. Application of the court to proceedings before a special. That page 31 of the provision. It says
36.
save 36C, capital C.
Yes.
Save as otherwise provided in this act, provisions of the Code of Criminal Procedure 73, 2 of 74, including provisions as to bail and bond, shall apply to proceedings before a special court. And for the purposes of said provisions, the special court shall be deemed to be a court of sessions. Person conducting prosecution before a special court shall be deemed to be a public prosecutor. This taken with 51. This taken with 51, which says provisions of the Code of Criminal Procedure to apply to warrants, arrests, searches, and seizures. Says the provisions of the Code of Criminal Procedure shall apply insofar as they are not inconsistent with the provisions
Release of a vehicle during the pendency does not amount to disposal of.
No, it doesn't. It is simply, it remains in the custody of the court, but it is handed over, my lords, to the person being released for the interim period. And the court at the time of deciding the case, trial, conclusion of the trial, will decide whether the seized the property which has been released is to be forfeited or to be
Confiscated.
So in these cases, it seems the applications were not filed, in some of the cases.
Some.
Applications were not filed before the special judge. Rather, those applications were filed before the magistrates. Magistrate must not be having any jurisdiction over the case.
Should not. Because the principle is that when a case under the NDPS Act is registered, my lords, it is to be tried by the special judge himself.
No, even the cognizance is to be taken by the special.
Cognizance is to be taken.
Right from that.
I think those cases where there probably orders are passed by the magistrate, maybe they have been produced before the magistrate, my lords, in the initial stages, and an application must have been made. And the crux is in Union of India versus Mohanlal, my lords, the court never said about conveyance.
Right. The court was concerned with proper.
Yes. It was concerned with disposal of the drugs.
Not only disposal, proper
Storage.
storage.
Yes,
Storage
of the contraband, the court was concerned.
And of course, disposal of
Mal.
contraband.
And in that judgment also, the court had dealt with the quantities. All the states were directed to raised before the honorable court as to the quantities that were there which had been kept. And there also, my lords, two notifications were concerned. In the first notification, SO number 1 dated 13/6/1989, conveyances was not included. But in the second notification, conveyances were included. Second notification is dated 16/1/2015. That provided for disposal of contraband and also for conveyance. The court said, my lords, that the notification did not in terms supersede the earlier notification, as there was no specific overriding of the earlier one by the latter one, which provided for disposal of all narcotics and conveyances. And it also provided for a different manner of making our applications, as also the disposal procedure. It was held that to the extent of such different procedure, the latter notification to that extent superseded the earlier one. And to avoid confusion arising out of the continued presence of two notifications on the subject, a set of guidelines were laid down in respect of where the trial proceedings had concluded finally, including appeals, revisions arising therefrom, then contraband seized after May 1989, where trial proceedings had concluded finally, including appeals, revisions arising therefrom, and where proceedings continued to remain pending. So the court made three classifications, my lords, and directed, my lords, that the concerned officer to whom the contraband was seized was to move the magistrate under 52A subclause 2, which the magistrate was required to dispose of as soon as possible under section 52A subclause 3. 6 months' time was given from the date of the order to all agencies to take steps to set up storage facilities for contraband as well as conveyances with provision of proper security against theft, pilferage, or replacement of the seized contraband. And all seized drugs lying in different places of storage were to be disposed of by the concerned deputy drugs controllers. Progress of storage and disposal to be monitored by a committee of judges appointed by chief justices on the administrative side.
No, but Mr. Is there any provision under CRPC or any other law akin to section 52A, which prescribes a particular procedure for disposal?
And my lords, I think this is
because
this is only so far as the NDPS Act it contains. And it was amendments were carried on in view of Mohanlal's study.
And there is no Supreme Court decision on this point, whether the special court or the magistrate has power to release with
I believe that's
I have given that judgment, my lords, in my convenience compilation.
Where is that?
My lords, page number 70. Page number 70, my lords, of my convenience compilation, your lordships will find, my lord, this is order of the year 22, Sainava versus the state of Kerala.
Page 70.
Page 70 of my notes of submission compilation that I've given.
Yes.
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 My lords, the appellant alleged, my lords, here in this case, my lords, may I read out the facts then?
No, just.
My lords, herein also, my lords, the vehicle was seized, my lords, for an offense under the NDPS Act, my lords. The owner was not charge sheeted in the case, my lords. Now, she filed an application for release of the vehicle, my lords, which was, my lords, by the learned special judge,
and also confirmed by the High Court, my lords. Of course, my lord, that application was filed under 451 of the CRPC, my lords. Now the Supreme Court, my lords, the Honorable Supreme Court at page 71, relying upon, my lords, Sundarlal Ambalal Desai, my lords, which is virtually cited in every vehicle release matter, my lords. The Honorable Supreme Court, my lords, stated the appellant at page 71, if your lordship sees, the appellant has urged inter alia that as per section 36C, read with section 51 of the NDPS Act, which my learned senior just read out, Criminal Procedure Code would be applicable for proceedings by a special court under the NDPS Act, and section 451 has an inbuilt provision to impose any specific condition on the appellant while releasing the vehicle. The appellant is undoubtedly the registered owner of the vehicle but had not participated in the offence as alleged by the prosecution, nor had knowledge of all of the alleged transaction. Learned Counsel seeks to rely on the judgment of this court in Sundarbhai Ambalal Desai versus State of Gujarat so and so, opining that it is no use to keep such seized vehicles at police station for a long period, and it is open to the magistrate to pass appropriate orders immediately by taking a bond and a guarantee as well as security for return of the said vehicle if required at any point of time. On hearing learned parties and in the conspectus of the facts and circumstances of the case and the legal provisions referred aforesaid, we are of the view that this is an appropriate case for release of the vehicle on terms and conditions to be determined by the special court. The appeal is accordingly allowed, leaving. And thereafter, my lords, following this judgment, a detailed judgment, my lords, has been passed very recently in the month of February 2024 by a 3-judge bench, my lords, of the Kerala High Court, my lords. That judgment, my lords, the specific query which has been raised by your lordships has been answered in that judgment. That your lordships will find at page number convenience compilation. The question that fell, I'll just read out paragraph number 1 at page 84. The question, my lords, which fell for consideration. Whether your lordships has it, my lords? Whether the jurisdictional special court can exercise powers under section 457 of the Code of Criminal Procedure to order interim custody of a vehicle seized under the NDPS Act 1985 is the short question posed in this reference. Now, thereafter, my lords, the relevant para would be, my lords, paragraph 9 to 12, my lords. That's page number 91 of the compilation. Running page 91. Seized vehicle idle and exposed to sun, rain, and the vagaries of nature till the completion of the legal formalities will only result in deterioration of the vehicle and its value. By keeping the vehicle idle and unattended, it becomes scrap by passage of time. When ultimately the vehicle is ordered to be disposed of, it will hardly fetch any value. This will not benefit anybody, including the state exchequer. In Sundarbhai Ambalal Desai versus State of Gujarat, the Apex Court underlined the necessity to pass orders of interim custody without keeping the vehicle idle and resulting in deterioration in its value.
Logic.
And ultimately held, my lords, at paragraph
That we have seen.
Yes.
See, the Supreme Court's order which you are referring to does not deal with the question.
Yes, yes, it does not. But
Kerala High Court has answered that question, but in the light of that decision,
Sundarbhai, and taking note of this,
Sundarbhai has no application. Sundarbhai was in a different NDPS was not, provisions of the NDPS were not considered in all. That question was not involved.
If your lordship is holding that compilation, if your lordship look at page 52 of that compilation.
52.
Yes, that is the division bench judgment of this court reported in 2022 1 OLR page 900.
Yes.
Lords may look at page 55, paragraph 5.
Yes.
Your Lordship, the purpose of the present petition is to persuade this court to exercise the power of superintendence over special courts to achieve the purpose of and ensure that the disposal of the drugs in terms of the guidelines issued in Mohanlal Supra takes place within a definite time frame. In response to notice issued in the petition, opposite party initially filed an affidavit dated 16th November 2021, not countering the actual aspects or even need for urgent directions. A note of suggestions was filed on behalf of the state on 6th December 2021, followed by two convenience notes, one by the opposite party and the other by the state on 22nd December 2020. The thrust of submissions by the state is that confusion has been created by section 52A requiring certification by, whereas power to take cognizance of the offences is with the special courts in view of 36A1D of the NDPS Act. Power to order remand also has been vested with the special court under 36A1C of the NDPS Act. It was accordingly submitted on behalf of the state that the word magistrate should be read at special court in order to avoid any anomalies in the implementation of the guidelines in Mohanlal. Now, this argument of the state, my lords, the division bench considered, and then the division bench holds like this, my lords may look at page 57, your lordship. Page 67, para 11, 57. Has your lordship got?
Yes.
It was noted that although the standing order issued by the central government required samples to be taken.
No, you are reading page
57.
57.
Yes.
Yes.
It was noted that although the standing order issued by the central government required samples to be taken at the time of seizure, there was no provision in the act itself to that effect. On section 52A4 NDPS Act envisaged the samples being drawn and certified by the magistrate in compliance with 52A2 and 3 of the NDPS Act. According to the Supreme Court, it was the central government which had to dispel the confusion. Nevertheless, the Supreme Court was clear that the process could not brook any delay, and the observations of the court have been quoted. And then the next page, my lords may see, para 12. Thus, the expectation of the Supreme Court was that the magistrates entrusted with the responsibility under 52A would act without delay, and further that the High Court would keep a close watch on performance of the magistrates. On the three aspects concerned with it, Mohanlal, that is seizure and sampling of drugs and psychotropic substances, storage and their destruction, the following detailed directions were issued. And they have brought out from Mohanlal, my lords, the directions. And then, my lords, may look at page 60.
Yes.
Page 60, para 16, my lords, please. The contention of the petitioner state as advanced by Mr. So-and-so and as reiterated in written submissions is that for the purpose of 52A2 to 4 of the NDPS Act, this court should interpret the word magistrate to read as special court, since in any event it is only the special court that has been entrusted the power under the NDPS Act to take cognizance of the offences committed and to try all offences thereunder. It was submitted that directions issued by the Supreme Court in Mohanlal Supra to the Chief Justices of the High Courts to pass appropriate directions on the administrative side should also be understood as directions on the judicial side, and if so done, it would speed up the taking of samples and verifications. And at para 7, the Lordship say, the above contention of the petitioner state in fact is based on the mischief rule in the law relating to interpretation of statutes. And then at para 18, the question that arises therefore for consideration is whether under 52A2 read with 3, power in regard to preparation of inventory and allowing applications for disposal of seized narcotic drugs vested on the magistrate can be interpreted to be exercised by the special court constituted under 36 of the NDPS Act 1985. Having carefully considered the above contention, this is not persuaded to accept it, particularly in view of the judgment of the Supreme Court in Mohanlal Sutra. So what the court was considering there was this, whether the magistrate can be interpreted, word magistrate can be interpreted to be exercised by this special court. Now, after this judgment was delivered, a single judge bench of this court, Millards, passed order saying that in view of this judgment and 52, in view of 52A, the courts were denuded of the powers of interim release of convicts. That is how this anomaly arose.
No, that is a division bench judgment or single bench judgment?
No, this on the basis of this division bench judgment, the learned single judge Millards disposed of a batch of petitions, criminal revisions, which had been filed and were pending over the question of whether the power of interim release was there in an NDPS Act of vehicles. The Honorable Judge said that in view of this decision of the division bench, the question of release no longer remained because 52A was applicable.
That must be here.
That is Justice Pujari's.
No compilation, which is that.
It must be there.
It starts from the page 65, my lords. The order starts. Page number 65. This is criminal revision number 404.
Yes, my lords, page 65.
And the order, my lord, the relevant para is at page 68. Paragraph 5 and 6.
Your Lordship may see from page 67. At page 67, sorry, page 66, paragraph 4. A division bench of this court in the above mentioned case, basically relying on the authoritative of the apex court in various decisions, have held as follows. They quote the findings of the division bench, and then at page 68, His Lordship says, at para 5, after the aforesaid judgment rendered by a division bench of this court is of the view that prayer for release of the vehicle in question of the petitioner no more survives, being subject to pre-trial disposal as per section 52A NDPS Act, and accordingly giving liberty to the prosecution investigating agency to seek disposal of the conveyance in question under 52A NDPS Act before the magistrate concerned. In that event, magistrate concerned shall deal with the same in accordance with law, more particularly in the light of directions given in the aforementioned division bench judgment of this court. Criminal revision stands disposed of. This was questioned, my lords, by other benches, my lords. Justice S.K. Sahu raised the question, my lords, for which the matter was referred for.
Please come to page 63.
Yes, my lords.
Where the division bench records the conclusion.
My lords. Concluding directions.
No. Just above paragraph 24.
Yes, my lords.
The last sentence of
My lords,
paragraph
it is
23.
not possible for this court to direct that the powers exercisable by the magistrate under 52A of the NDPS Act could be exercised by the special judge under section 36 of the NDPS Act.
Oh, that was in a different context. The court, the division bench, held. Agreement must have been made. that wherever magistrate, the word magistrate is mentioned under 52A, that
It
power should
means
be
the special.
exercised by the special judge.
Right.
That was negative with this observation, that no, that magistrate is having power of a magistrate before whom the seizure can be met and who
Right.
shall be responsible for. So this is the background in which this observation has
Yes,
been made.
Milords. After Milords, this judgment of the division bench, another division bench judgment came relating to vehicles which had been seized, remaining lying in the police station.
Including NDPS cases.
Yes. There, Milords, the order was separate. That is, Milords, reported in 2022 85 OCR 730. State of Odisha versus the register.
If you can argue with the aid of your mobile phone, then you should have a tablet.
I am sorry, Milords. I was not aware that I was to appear here. Because I had kept the note in the mobile phone, Milords, I am able to place something.
Yes. So you are referring to which page?
Not in the compilation.
Not in the compilation.
All right.
Ashish, what is it? Ashish.
Ashish Ranjan Man. But I have filed a note. Is it on record?
Let us see.
Which item?
No, in this item wherein I was appointed amicus, Milords, I have filed a note dated 23rd of April.
Printout value, Ashish Ranjan Manti. Value.
April दिन करছিলে না ভাই জানুয়ারি তারপরে এপ্রিলে এপ্রিল 2024 গেল
I believe the matter was listed when your lordship was sitting, my lords, with Justice Sahu, my lords. It was there in the list, and at that time I had filed it.
All right.
I'm not sure whether it's.
All right, we will list this matter again on next Tuesday. So in the meanwhile, you just give us. And surprisingly, there is no Supreme Court's decision.
Except that Sainaba case where they.
Sainaba is nothing.
He cannot say that it's a.
There is also a judgment of Karnataka High Court, madam. Division bench judgment. In same point, let's see, madam.
Is there any decision of Calcutta High Court? Let's find out.
Karnataka High Court judgment is filed on same point.
2 p.m.
Yes. What is that? Karnataka?
अच्छा अच्छा
So what is there?
Paragraph 59, last paragraph. For the region stated above, we answer the reference under the matter conferred with the power. We will consider the application for interim custody of conveyance of vehicle under the provision of section 451, 457 of Code of Criminal Procedure in cases arising out of provision of NDPS. Last paragraph 59.
Yes.
Ratnama persisted.
Yes, this Karnataka is direct on this point.
Yes, yes, ma'am.
Que déjalo tipo.
Third, some
Law Karnataka.
all these matters for further hearing on next Tuesday. We taken up at 2 p.m.
Item 53. I apologize for second.
Oh, sorry. Give us a very effective assistance.
My lord, before my lord proceed with the cases, today I am getting a updated list, my lord. My lord, I had the case number and the serial number I have given. My lord, the first batch of cases, item 53.
52.
Fifty-three.
53.
1358.
What is the page number of the list?
36.
36.
My lord, last occasion, my lord wanted that whether we should accommodate those institutions.
Just a minute. You have given us
Yes,
the
yes, yes,
list.
my lord, yes.
So in the first group,
Yes,
hard copy has been submitted.
yes, my lord. And my
Within
lord,
time,
yes.
you are going to permit them.
No, now I asked them for giving in writing that we should permit them. They're telling if we permit, then so many institutions are there, they will produce. If my lord gives a direction, we will immediately do it. Otherwise, we are bound to give. My lord can give a direction, we will do it.
All right. There is a batch of such
Not submitted in time.
Huh?
Not submitted in time.
Not submitted within time.
Yes, my lord.
So their cases are gone.
18 cases.
18.
Yes. That is item 54, 55.
I'm appealing for the petition submitted or hard copy within time, but they didn't accept.
That is different.
And my humble submission
For
lordship
that,
would
you
be,
may have to file a suit.
my humble submission of lordship before the lordship would be, this is not the case of giving first time NOs.
That we understand.
This is renewal.
That we understand.
And mechanically, they are saying these are the deficiencies. But the lordship can look at page 50, page, my lord, item 54.
We will take up your case 54 separately. All right. According to you, you submitted.
Yes,
according to them.
categorical have taken amendment.
All right, they may deny. File your counter affidavit. in
Yes, my
this
lord, I will pay.
54 ka likhna.
No, I will, you have filed on that day, I will prepare my action.
Item number 54.
54, my lord, WPC number 16423 of 2020.
WPC number 16423 of 2024.
Number
4
4.
weeks time is allowed for the DMET.
Additional
file
affidavit.
Counter affidavit. Stating as to whether the petitioner had filed its application for renewal of NOC within time, either by either online or otherwise. Yes.
Then the my lord, item 50.
Just a minute. So can we dispose of 53?
Yes, ma'am.
These matters 1
Yes.
to 10.
1 to 10, yes, my lord.
1 to 10 we are disposing of.
Yes, my lord.
This is not in dispute. We will incorporate also some introduction. Okay, we are just
Operative question.
the operative part of it. The petitioners were admittedly granted NOC by the DMET for the academic stop for a renewal of NOC for the next academic session, that is 2024-25. They were required to make applications online. First off, online by which date?
Date was, well, they have filed in time.
And that we want to mention.
Yes, I
Saying that hard copy was submitted before the last date. So what is the date?
But the different dates were there.
Different dates are there.
Different dates.
Last date is one date. They
No, my
might have
lord.
submitted on different dates, but the last
Different
date is
dates for
different.
No, it happened. In each case, we are giving them 14 days time.
Oh.
In each case, we are giving them 14 days time.
Different dates.
Time within make their sectors for online. Before particular respective dates. First off, it is the case of these petitioners that because some glitch in the portal of the DMET, they could not apply online and they were thus compelled to submit hard copies of their applications for renewal of NOCs for
No, my lord. They have deficiency complied with.
Compliance of
Deficiency.
Application
Yes.
was everything was online.
Application was in the time.
Yes, compliance was done.
Fresh. Renewal as well as fresh. As well as fresh online.
On account of technical glitch.
on account पूरे उसको काटने the petitioners in the present batch of writ applications were admittedly granted NOC for the academic session 2023-24. The top, they had applied for a renewal of the NOCs within time for the academic session 24-25. Stop. Certain deficiencies were pointed out by the DMET while considering their applications for a renewal of NOCs which were communicated to them with them which were required to be rectified within stipulated time.
14 days. 14 days.
Within
Uniformly 14.
14 days.
14 days. First off, is the case of these petitioners that they could not comply with the with the respective communications because of some technical glitch with the portal of the DMET, comma, comply. They could not communicate the compliance of removal of defects.
Yes.
Deficiencies.
Deficiencies.
Removal of deficiencies online because of some technical glitch with the portal of DMET. First off, they were thus compelled to submit such communications, submit hard copies of such communication with the office of the DMET. First off, there does not appear to be any dispute that the hard copies were received by DMET within time, as stated by learned counsel for the DMET based on the instructions which he has received. Full stop. Next. Learned counsel appearing on behalf of ET states that if the court permits, DMET shall consider cases of such institutions for grant of these institutions for grant of for renewal of NOCs based on the hard copies of the compliance report which they have submitted. So stop. Considering the admitted facts and circumstances, the DMET is required to consider the cases of the petitioners based on the hard copies which the DMET has already received on the question of grant of renewal of NOC. So stop. We make clear that if the DMET finds that some other institutions had also submitted their hard copies within time, it will be open for the DMET to consider such cases also for renewal of NOCs. Next, these applications stand disposed of accordingly.
Including fresh also, these cases are within time, renewal as well as fresh cases are there. The first one, the one I was arguing was a fresh case.
Just a minute.
New one.
53 item.
53.
You are in 53.
I was in 50.
You think the first one is a fresh case, not
Fresh
renewal?
case. As well as fresh cases are
Also fresh. Renewal.
Also fresh.
Yes. Renewal.
It relates to removal of deficiencies.
Deficiencies.
Either
Deficiencies.
fresh or renewal.
Yes. Yes. Deficiencies. Removal of deficiencies.
All within time.
Within time.
No, but which are the cases relate to renewal and fresh?
Only
Renewal and fresh, can you distinguish?
Lakshmidhar is fresh.
No, that we have not.
581 is
Council are there, they can say,
13581 is fresh.
okay.
Yes.
13584 fresh man.
Fresh,
Fresh. 13588 renewal.
renewal, all right.
13589 renewal. 13590 fresh man. 13591 renewal. 13593 renewal. And last also 3 items.
How many briefs you are
10.
having?
10.
And Mr. Sethi, same name, so different courses. Same
For
name, different courses. All right, all right, all right.
Last 3 my lord.
Check.
17211 fresh my lord. 17252 my lord. That is fresh my lord. 16556 my lord. That is also fresh and
Year renewal can fresh man. These institutions have applied for grant of applied online for grant of NOC before DMET.
Yes.
Stop. DMET had pointed out certain deficiencies which were required to be removed by these institutions. Stop. It is the common case of the petitioners that they had attempted to make online communication with the DMET as regards compliance of the deficiencies pointed out by the DMET. But because of technical glitch, the communications could not be successful online. Technical glitch with the portal of the DMET. So they had, however, submitted hard copies of the compliance report within the time as stipulated as specified by
Yes.
Stop. And counsel for the DMET accepts that hard copies of the compliance reports were submitted by these institutions in the office of the DMET. Stop. He accordingly submits that if the court permits, the DMET shall consider their cases for grant of NOC. Stop. Considering the admitted fact that these petitioners had submitted their compliance after the deficiencies were pointed out by the DMET, within time as stipulated by the within time, that is within 14 days of communication of the deficiencies, we direct that let cases of these petitioners be considered for grant of NOCs based on the compliance report, based on hard copies of the compliance reports submitted by them. Stop. these applications stand disposed of accordingly. So these are 53.
Yes, my lord, 10 items.
Item 54, sub-item 6.
Just
I fall under the same
we
category.
are coming to. We make it clear that the DMET shall be at liberty to consider such cases where hard copies of the compliance reports for grant of NOC. In other cases where hard copies of the compliance report have been submitted by the institutions within time.
This is NOC for the year 2024-25.
24-25.
24-25. Now we'll click on NOC one.
First line.
First line for the academic session 24-25. Yes, 54. 54.
54 sub-item 1 Miller, I am concerned to that item. There is a delay of 6 days Miller in filing of my compliance through online mode Miller. It may be taken up next day Miller, because I am convinced to
All right.
delay is bona fide.
All right, delay bona fide, that we will consider.
Category.
We are not, we'll consider your case.
Denied.
File your affidavit. 54.
Yes, my lord.
Actually, I fixed up a date because
We are fixing date.
Admission is September 30th
4
September.
weeks.
my
4 weeks.
lordship last date fixed up is 31st of this month Miller.
August.
August. Your lordship extended
For
the
issuance of NOC.
in case of other matter in which senior and respected senior officer Mr. Misra was arguing Miller. Your lordship has been pleased to extend the date to 31st August for consideration of renewal of NOC Miller.
No, that was in a different
Yes,
context
yes,
altogether.
When voting, those NOC was granted after
Yes.
the date
Cut off
of
date.
filing the application.
Yes.
That was the case.
That was different. That was the renewal of NOC, which he could not apply within
Yes.
time because of
Delays.
NOC was granted
Delay.
My
later.
humble submission to you, in the case of renewal, if a lordship is granting the same way granted
no.
because it's a renewal. I
We
can
have,
understand it
the
in
court,
first NOC.
the court.
I will give a reply to the
Reply,
counter file.
whatever.
And 55 is cases
54.
where the applicant has denied.
Yes, my lord.
Deficiency of within the date of deficiency, online application was not.
55.
54.
My
3
lord.
weeks file your counter affidavit.
Yes, my lord. 55, my lord. These are,
They said they asked for another date.
yes, what has happened, my lord, I have got the instruction in 55. They have denied for inspection because this year they
Election.
were inspection of the institutions after deficiency has been complied with. We had fixed time for them for inspection online. In most of the cases, they have given the refusal for
Election.
inspection on the plea. Election was there. So in this case, I have got the instruction. If any institution has been given the date prior to 2 days or after 2 days of the election, we will re-inspect them. We'll give them.
So for that, you have to tell us which is the institution.
Yes, madam.
Generally.
I have to get these things and I will give because I have today at 1 o'clock I got this instruction. By later, I will give it. Let it come next week, Monday.
55. Next Monday.
But if it's called in a day or two, it is better. My friend will agree.
No, my lord, I cannot immediately. It's so pressurized. I cannot do immediately. Let me Monday come.
That is no deficiency at
Yes.
all. Agency.
We cannot declare that there is no deficiency.
I fairly concede to that, my lord.
Yes,
But my
and even you
humble
cannot
submission
say
is-
that.
My humble submission is where there is no
Please, Mr.
deficiency, mechanical
Please.
deficiency.
Mister,
I'm sorry. My
let us don't raise our voices.
No, my lord, I used to because my grandfather and yes, they had a hard of hearing. Therefore, I
We
used
should
to
not blame him. Yes.
My lord, 56 is a lot of deficiencies are there.
If
I
you
will file
continue
a
like
counter.
this, we will become hard of hearing.
My lord, 56, there are a lot of deficiencies. I will give a counter to this.
50?
56 1.
There was one case where we that fire safety
No, fire is there. I have to
was
give
not
counter.
required.
That is that. No, that is they have wood done yesterday. They have wood done yesterday.
56.
54.
Yes, 56. There are, no, 55. Listing next page. Monday.
Can I pray one thing? 55 at 2 o'clock on Monday.
2 o'clock.
Oh, great.
2 o'clock.
54 hour.
My lord, the
One of the matters.
54, no.
May I-
54, they have to file counter affidavit.
May I pray, my
Come
lords?
after 3 weeks.
my lord, 57, 57, my lord.
May I pray, my lords? Item 54.
54 is concerned, my lord. My item WPC 16423 of 24, my lord. In that case, they have filed counter. Also, I have filed rejoinder.
Which one?
Item 54.
So you want? No, which, what is the case number?
WPC number 16423.
16423, you want dismissal today? Next day.
Monday.
Sir, you did not submit your application within time. What can be done?
No matter.
This is not an endless exercise.
The renewal of my NOC.
All right, so you want it to be dismissed on the next day,
May,
whenever you want.
Monday.
All right, next day.
may I pray, my lords? Item 54, sub-item 6. I have submitted my
If counter affidavit has already been filed. 50, item number 54, we have directed file counter affidavit. If no counter affidavit has been filed so far.
My lord,
item
57, 57, all these matters regarding fire. So I have to give counter in this matter because last
Just a
operation
minute,
there
what
was
happened to 56?
57.
56.
56 press NOC. Is there any merit in this case?
Yes, ma'am.
What?
I have removed all the deficiencies. Now, should kindly have a glance
Within time or beyond time?
at- My lord,
Within the time prescribed. The time.
Just
So that will come on along with that.
fire safety certificate not compliant. Building
57.
completion certificate not
Come
compliant.
with 27.8. Yes, but beyond the time.
yes, my lord, beyond the time. But I have complied with that.
Compliant, might have compliant.
It's not compliant.
Yes, my lord.
Then same category as that 54.
56 is different.
No, but complied he's saying, but beyond the date.
Yes.
So
50,
this
54.
54 also not submitted within
Yes,
time.
yes, 54 is not compliant in time.
54 sub-item 6 falls under category 53, my lords. I had submitted on time the physical copy on
Which item?
well, item 54 sub-item 6 WPC 166.
54, those matters will come after.
He's saying that.
Monday.
When it's coming under the category of
No, just a minute. You are saying you fall in the first category.
my lords,
You
because I had submitted
the
my
hard copy within time.
yes, my lords,
compliance.
within the complaint.
No, was it fresh or
That was received by them also.
fresh or
That was renewal. That was renewal.
When did you apply?
Well, they had given me a time of 14 days.
Whether your matter is listed.
My matter is listed at item 54 sub-item 6. It's WPC
WPC
16624.
16.
Not submitted within time.
So it's submitted within time. Lordship, see page 25. Annexure 4.
All right, we will take up tomorrow this matter.
Khali 166.
Please seek instructions. He is saying that it was received within time.
Yes.
How do you say?
Well, it's annexure 4 because on 1st of May, that was the, it's falling within the 14-day time which they have fixed. I had given my physical copy of the deficiencies and that was received by them on 2nd of May.
End of May. You gave it on 1st of
On
May.
1st of May.
They received on 2nd.
2nd.
That is 14 days or beyond.
Then that 2nd of May is the 14th day.
No.
And
Then it's all right.
1st of May is the 14 within 14 days which I'm submitting. On 20th of April, my lords, they issued the letter. So the 14 days falls on 2nd of May. I had given on 1st of May.
According to them, it was not received within
Yes, my
time.
lord. I will give a counter to this.
They
I
have
will give
filed any
I am not
counter to
giving
that.
counter to this case, my lord. I will give a counter, let it
It's
come on
within
Monday.
14
You
days.
can file.
I will file a counter, let
Not
it come
now.
on Monday.
Monday.
Yes, ma'am.
Monday.
57, my lord, these are all the fire matters, deficiencies. I will file counter in all these cases at least 7 days time. Documents has to be produced because they are submitting some documents which I have to rely and get a reply to that. 7 days time should be there.
Here, the problem would be that, of course, this is a common order dated 9/7/2024. All these, at least the 3 matters where I'm appearing, these matters, there were inspections pursuant to the directions of this court earlier. they found everything to be in order and they gave us the first NOC. These are all renewal NOCs. So in the second year, now they are saying that we will not grant it.
Rightly. They are not obliged.
No.
I'll give
only problem is that we may miss the cutoff date if they take 7 days. And there are judgments which say that this will not apply to colleges which have been established prior to that coming into of the act of the rules. Then this is also.
When there are so many questions, then all the issues will have to be decided. Whether when was the college
Let them
established?
inspect. All that we request is last year they had inspected and they found everything in order. We are in the next year and now they have stopped. So this will have a cascading effect so far as the.
Have you increased the size of your building?
No,
Because
nothing.
3 floors or something it is not required there.
Same building. All fire installations are in place.
I'll get all the information.
So we will see.
Can you do it early?
Yes, yes.
Because they are saying even if you are supposed to get, if it goes beyond the date, they can't get.
2 weeks. Filing counter affidavit. 7.
May I request for a shorter date?
2 weeks.
My friend was asking for 7 days. He was asking for 7 days.
Mr. Mahanti, 7 days,
After 7 days.
10 days.
7 days minimum. 10 days after it, let it come, I will get it.
10 days.
Item 58.
My lord, 58 is not submitted in time.
My lord, 58, the last two items, some items if your lordship should see, I had pointed out, they had stated that regarding that pendency of the writ petition. But in this case also, we have submitted in time on the 13th day, in fact.
That is
Because we
already
received
covered.
the notice on 21st of April, 22nd
covered
of
case.
April, and we submitted on 4th of May.
58, 8 and 9,
4th of
serial, both these are covered with this.
Sorry, my
Allowed.
lord,
We are allowed.
22nd of March we received and 4th of
That is
April
what within
we
14 days they have submitted. That will be covered with that case.
It's covered, any other
Yes,
case covered.
Yes, first.
case.
Yes.
It may cover it.
Any other case. So it is covered under any other case.
Because it is the other case which they have cited
covered
that
with
is pending is
53.
regarding our request for inspection. Because we had submitted the documents in time. So we had filed a separate writ petition for inspection, which is still pending.
So
So
naturally
in
we'll
the
take into
meantime, the second writ petition had to be filed because they rejected my application.
No,
State
if you admit that it is the same, then we can.
Yes, yes, same,
implement
man.
53.
Same.
So we can
It is a
implement that order.
Yes.
Renewal or?
renewal.
Which item?
Item last two.
8 and 9.
8 and
8 and 9.
Item,
8 and 9.
WPC 18000 and 18003.
Is that hard copy?
Hard copy.
Yes.
Renewal. Renewal.
First item.
Same as 53, that will cover, my lord.
That, my lord,
So there are types of order, one relating to renewal, and the grant of so renewal. These two orders.
These two, my lord, renewal, not
My lord,
fresh.
WPC number 15858 of that just above, my lord. 15858. Here the defect they have shown, they have not given the details of the appointment of principal, my lord. I have on within the time 10 days I have already submitted a contract. 15858 of 2024 National Institute of Health Science.
we will file a counter to this whether he has given or not.
File, I have also filed rejoinder. I have also filed my rejoinder.
You have file counter.
I
You
have
have filed.
I have,
You have filed.
rejoinder, my lord.
We'll consider that.
I'll see to it. My lord.
For-
Monday it will come, let it come on Monday.
Within time I have
Monday.
filed. Fresh
Let it
LOC.
come
We
on.
will see.
My lord, item 210 of the
We'll
58.
see when these matters should be.
Monday.
Below, my lord, WPC
My lord,
17,494. That is renewal. 6 days delay for
6 days delay we cannot.
your lordship passed order, similar order. my lord.
What?
Because of the 16/1/2004, they are given fast NOC. 2023-24.
That is different. Let us see, let us,
my lord,
Exactly same. man.
let us,
That will come 27, that means.
which one?
no, that will
Delay. Item
belated grant of NOC.
54. No, no.
Which is your case? 16986.
My case is 17494 of 24.
Oh, one?
17494 of 24. Radharamana Institute.
Is that item?
Item
58.5.
58.
58.5.
58.5, my lord.
Not submitted within time.
My lord, 6 days delays. Second renewal of second.
Where is that?
Later.
Related grant of
Did not submit within time.
Yes, my lord.
Yes.
So it is not because of, is it a case of renewal?
No, my lord.
Renewal, man. Renewal.
When was the renewal granted?
First renewal granted on 16/1/24.
Then this case is.
Last date was 21/2024, my lord, 4 days before.
So he says that.
Renewal. Delay on the ground of renewal, man.
Let it come Monday, I will verify, and if it is so, I will say that it has been displayed.
58.5.
Monday. My lord, the item number 2 and 3 of 58, that is Katie School of Nursing, Katie School of Pharmacy. Last occasion I was telling, they have given, I have got the letter. We have in one case, nursing case, we have not accepted and asking for applying again.
All right, just a minute, one by one. Item number
58.2.
2 and 3, I will file counter to this.
58, first case.
First case, my lord, regarding that email on the that pointed
Wrong
out, my lord.
address.
Wrong address.
Which one?
And in other courses, my lord, the same rule applies. They have sent by email also as well as by speed post they're pointing out the deficiencies. But so far as the nursing is concerned, everything is online only. So far as the pharmacy and physiotherapy is concerned, they have sent the communication both through online as well as offline by speed post with AD.
So have you filed your affidavit?
No, they have. 50
That where the email address they sent through a different email and you replied on that email
my
for
lord.
which they have not
I have
got.
on that day, my lord, I got the instruction. We have sent on his email
That
address.
is saying.
Yes,
But
and
it's
he has
not the
supplied, he has
registered email
given
ID.
this.
Because of
In
the
June,
glitch, we
have
could not.
been in April. He has submitted in June by the same address of ours, our mail. That I will give the counter. That is, I have got the email.
Monday.
Monday,
So that is nursing.
nursing.
12/7.
Can it be Tuesday if subject to a lordship? Means if it is
Tuesday.
Tuesday.
Pharmacy is what? Pharmacy.
And the 6th is the same.
No, 58.3 is what?
No, 50.
That is different. Okay.
That is
8.2 and 3, my lord. In both the cases, I will file counter.
58.7 is same email, my lord. 1790.
13/8 together.
That is
58.
17904 and 17905.
All 58 matters come on the Monday,
Yes.
Tuesday.
Tuesday. All right.
Tuesday, my lord, because at least some time should be given.
58.8 and 58.9.
Yes.
Yes.
Item 59.
Obliged.
And
My lord, this is.
certificates are.
Yes, my lord. That is again a time should be given to me to give the counter in fire certificates. Fire
There is a
certificates.
case, my lord, where fire certificate is granted till September 2025, my lord. But now they are rejected. Now there is a communication between the fire officer and them. No opportunity is given to me. But certificate is given to me valid up to September 2025.
All right, opportunity is not required.
That is the intercommunication, and now they are saying that certificate is not there.
Let them file a.
When?
Yes. My lord, 60. All the.
No, 59.1. You'll file affidavit.
Yes, my lord. 1, 2 both.
1, 2 both.
2 weeks.
2 weeks.
My lord. 6. All these 4 matters are covered. I have written the. I have given the number also, my lord. OGC number, WPC number. I have given number. I have got it.
Pilots convenient. I am providing a copy.
That Biswas case.
So same date, 16/1/2024.
My lord.
The granted was the NOC was granted on 16/1/2024.
In my top case also same date.
No, my lord.
Dates must be different.
Yes, they're different. They're different.
So give slips with your dates.
In my case, date is same, my lord. 16/1/2024.
My lord,
My top case.
my lord, what do you think is that they have given a belated
Which
NOC?
case? My lord, the 60, item number 60, top sub item number 1. My case, they will.
17950.
Yes, my lord.
16/1/2024.
Yes, my lord.
And your case? Who is?
18414.
18080.
No, 180. 180.
Okay.
Mine is last. 18414.
तो जाओ, हमारा age तो covered.
Date is 17/2/2024. NOC.
That is covered.
It's covered here, Lordship. This was case.
So one are covered.
Yes.
No, hold on.
Other two? I'm
The
giving
two also covered.
18080. Who is
dates,
there?
dates.
Date के तो
18080 is whose?
180 not mine. Ashu.
Mr. Parsuram Das.
Yes.
So you're looking for the date?
Date of first NOC issued NOC on 10/3/2021 and thereafter
No, no.
renewal
Last
renewal
one.
of NOC.
Yes, read.
Yes, that is.
10/3/2024.
Yes, my lord. Little states.
22/1
22/1.
22/1/2024.
Date of grant of NOC.
20.
Date
Yes. Yes.
And 18188.
Second
Double
case.
कितने? Double take.
18188.
Yes, कितने
Date,
cover
date.
code? Date.
18188. The date is 22/1/2024.
So same date in both.
No.
अरे कौन same no?
Yes, yes.
Second is 3/2024.
Which one?
Are you sure?
WPC number.
WPC number 18080.
What is the date when your NOC was granted?
My lord, there are two items. So WPC number 180. In that case, the NOC was granted on 14/3/2024.
14/3.
14/3/2024.
And the next, another case?
And in the other case, 18188.
Huh.
WPC 18188. The NOC was granted on 22/1/2024.
It's also.
22/1/2024 in 18188.
My lord.
And 14/3/2024 in 18080.
18080.
Are you sure?
My lord.
We were against. Yes. 61?
Yes, 61. 61, case of renewal. Case of renewal. We applied, everything was done, inspection was, Lord, it's a very slightly different case. Lordship, my lord, their own guideline says for removal of any defect, give 7 days time. We'll give 7 days time. In this case, my lord, they gave 3 days time. They say 7 days time. They gave 3 days time. So we said, Master, undertaking for 2 more days. That means within that 7 days. Where, and in fact, we thereafter they did act upon it.
My
They
lord,
said that
regarding
they did not act
principal.
upon it and rejected that the principal doesn't have the merit, requisite qualification. But page 50, my lord, I gave with the guideline to page 50, their own guideline, government guideline. Page 50, the last part, 7 days time.
Let them file affidavit. Why did you not give him
7
My
days
lord,
time.
my lord, this year the problem was because the time was fixed for September 30th to admission.
But that
So-
is there, still time
Just
is
tell
there.
it.
Yes,
Please.
sorry.
So what has happened? We have shot down the dates, but if you would have given the principal present before the authority with all documents, then we can inspect and we can check and get it
We
done.
will apply.
That is the only thing that can.
Your lordship, my direct will appear
My lord, fix a date.
3 days.
3 days time may be given to them to place before the DMT with the principal and its all certificates for compliance. So that if it is due, we will
Within
do
3
it.
days will appear, my lord. That the rule says.
61. The This is fresh NOC.
The NOC, it's renewal.
Renewal.
It's renewal, sir. And the time, that period of 24, 3 days.
And Senior Counsel appearing on behalf of the petitioners, both the cases, has submitted that an application was filed for, was made for NOC.
Renewal of
for
NOC.
grant of
Renewal of NOC.
For renewal of NOC,
24-25?
24-25.
BSc Nursing Course.
Sir.
Report.
Under the guidelines issued by the DMET, the DMET was required to grant 7 days time for removal of the defects. So, deviating from its own guideline, DMET required these petitioners to remove the deficiencies within 3 days.
Sir.
So, next, Learned Counsel appearing on behalf of the DMET has submitted that if the petitioner appears before
the DMT, the committee, chairman of the
of the colleges appear before the secretary DMET. With secretary, is there any secretary?
No, my lord.
DMET.
The chairman is the
chairman of the DMET.
Yes,
With
all documents.
Documents showing the removal of deficiency, the DMET shall consider their cases for grant of renewal of NOCs.
Fix the period, sir, and 9
within 3 days.
Will your lordship fix the period for that?
No, we are giving the time. When you will appear on Thursday? Tomorrow?
12th or 13th?
Is 9th or 10th copies are there?
On 9? On 9?
9th, sir.
Letter is 12th, my lord, because
12. All right.
12th.
It's 12th at?
Any time, my lord, fix. No problem.
When you say
2 o'clock.
2 o'clock. No, not here, there.
Yes, my lord. There, yes, my lord. 2 o'clock there also.
Great. Urgent copy.
Item 61, my lord. Top item WPC 18422 for 24.
Same order.
Same. But I don't know whether when I submitted.
They have rejected my application. This is the renewal for NOC. They have rejected my application. Already I have complied with the deficiency.
No, because your principal doesn't have 15 years experience.
I have complied.
Which is your case?
Next item.
18422 sub item. Item 61.
So you go there.
Let him be
What do you want?
on that day. Let him same day. Let him be present.
Your principal will go with his documents.
Yes, my lord. May I pray item 15 content matter tomorrow, my lord?
Right? Let us see. Let us try. Content matters are likely to be taken up.
I would have special fix, not specially. Yeah.
Item 3.
Test admission item number 3.
You are free.
My lord, all the items will come at 2 o'clock on Monday. Yes. All finished dates.
Not all.
Different dates.
Those who has been given dates, that will come at 2. Given dates.
All the cases, dates given, all of them will come at 2.
Yes.
May I be pardoned to make a mention?
Item number 3.
In item number 3,
petitioner was directed to be given the benefits under the R&R policy, that is employment. We have now asked him to appear before the authority today with the document so that the appointment can be issued. For that, we need 7 days time. If call 1 week after, he can get the employment.
They only call for only 2 persons out of 5. Please wait for 1 week more week.
Here only one is there.
When did you file your writ petition? When had you filed your writ petition? I am filing in year 2019. And we are in 2024. Please feel happy that something is happening. All right, as requested on behalf of the estate, place this matter on 1 week within top 5 cases.
Item number 4.
Widely covered under Orissa State Abolition Act.
Odisha State Abolition Act is continuing in
Orissa
2024.
State Abolition Act, as per local arrangement, forms, it is to be hard by division bench. But inadvertently, this has been decided by single bench.
So now
That
you
is
are
one part. So far, the merits of the case is concerned, Orissa State Abolition Act is a local act. The objective of the act is to do away with the intermediary, abolition of intermediary system, whereas the tenants under the intermediary were protected under section 8(1) of the act. Section 8(1) read with explanation to clause A to section 5. So section 8(1) is continuity of tenants, continuity of tenure of tenants. Any person who immediately before the date of vesting of an estate,
So we will
the
see
state
later.
government,
We'll see later.
What
Who is
is
appearing
the-
for the other side?
Hmm?
You are for the other side.
No, but I'm for the state, other state notice will go, but the first allegation that it is assigned to division bench has been heard by Honorable Single is not correct.
Survey Settlement Act.
Yes, you will also may come to page 15. Writ application has been filed, styling it as an application under the Settlement Act, which has been assigned to Honorable Single.
No. That is
The annex all passed by the National Settlement Commissioner orders.
Page 15, it's similar, so can clearly mention.
So did you raise this objection?
the relief claimed in the writ application was confined to Orissa State Abolition Act.
When the matter
order
was,
which has been
Mr. Counsel, when the matter was heard by the learned single judge, did you point that out, that you should not hear?
Hello?
Because,
Is this matter after 4 weeks? We don't have so much of questions.
$36 सीरियल था तो काल था 36 था मैं मेरा
क्या है प्रॉब्लम?
प्रॉब्लम क्या है मेरा एक रिटायर्ड लोग है
क्या हुआ?
रिटायर्ड पर्सन में
हाँ, you are retired person.
इन पर्सन मैं सीरियल नंबर 36 था
What is
टुडे
चाहिए क्या?
था 40
ନାଇଁ ନାଇଁ ରୁହନ୍ତୁ ରେସ୍ପଣ୍ଡେଣ୍ଟ 2 ଟା କିଏ ତାଙ୍କଠୁ ନୋଟିସ ଟା ଫେରି ଆସିଛି
नहीं तब हेरा डिस्पोज हो जाएगी दुईटा डिस्पोज हो जाएगी जो केसटा हमरो
saying it may be heard but I find that notice has returned answered from
What क्या प्रॉब्लम क्या है? You are not getting your pension.
केसटा कौन केसटा क्या है
डिपार्टमेंटल एग्जामिनेशन डिपार्टमेंट कोर्ट
प्रमोशन
प्रमोशन के लिए
प्रमोशन के लिए है तो आपको पेंशन मिल रहा है?
ये मिल रहा है।
तो वो इतना अर्जेंट नहीं है कि आप चूंकि आए हैं तो पहले सुन लें, ठीक है? अगर आपको कोई परेशानी है, किसी यहाँ पे जितने भी लॉ, सारे बड़े कॉम्पिटेंट लॉयर हैं, जिनको कहिएगा अभी इंगेज कर लेंगे आपके लिए, समझे? लेकिन आपके चलते सुनवाई पहले नहीं हो जाएगी। ऑलराइट,
नहीं समस्त केस एमती आसुची आपनकर भी आसीबो यदि आसी परनांती वकील दे परिबे वकील माने आसुचंदी समस्त से होउची हां डेट हबो डेट गुडा कर दे
May I be pardoned to make a mention, my lord?
Item 29 for withdrawal.
no, it will come after 4 weeks.
May I
Lord,
be
item
pardoned to make a
29,
mention, my lord?
That is for withdrawal. I have filed one IA for that, Lord. That may be considered.
Item 7.
29.
Come on.
Item 7, I am entering.
Item C.
Sir, copy, let it come on some other date.
You file your
Yes, I'll file it,
see
madam.
and you give him a copy. That
Let
is
it come
your
on some
interest.
other date, madam, after 15 days.
No, let it come tomorrow.
you'll pass the same
Item 17, my lord, I will call
May I
them
be
at
pardoned to make a mention, my lord? Item 32, my,
I will call them at 2, my lord. Item
All the matter. Yes, madam.
my lord, item 32, my lord, can I pray my lord to call this matter tomorrow?
Yes,
I'm for the respondent.
all the matters will come. All the matters. will come.
Item 6, my lord, next week, my lord. Item 6 next week.
Item 4.
Which item?
Item 4 may be called tomorrow.
Your Lordship, I
Which item? What do you want?
wants adjournment of 1 week
Which item?
Item 6 next week, my lord.
All right.
Your Lordship, item number 30 may be taken up tomorrow
All right, all the
at
matters.
2 o'clock.
will be
Much obliged, Lord.